the original site, which was assigned in July of last year, but it's not been taken up. My lord, your lordships had been pleased to have the matter listed on a couple of occasions, but your lordships could not sit on that particular day on Monday. I'm only praying that this matter be taken up.
Give it.
Thank you for mention my lord, item number 131 and 132 and 133. Item number 131, 132 and 133. My lord, the private respondents were working as havaldars at airport. They were employed under the Department of Customs. They were involved in smuggling of gold.
We are not hearing your matter.
I feel also, my lord, I'm
Yes.
praying for upgradation. If you'll also kindly
Why?
update it on
Sorry.
any day. Subject to lordship's
No
convenience,
upgradation. Sorry.
because a contempt application has been filed before the tribunal.
Because?
Because the contempt application has been filed before the learned tribunal.
Yes.
The learned tribunal has fixed 19th of this month for hearing of the said contempt
What is the compliance which you are required to?
All right, people also, my lord, after proceedings, my lord, their services were terminated.
Yes.
Therefore, they preferred an application before the learned tribunal. Tribunal set aside without looking into evidence or any material facts the orders passed by the department, directing them to be reinstated.
Yes.
Now they have filed an application for contempt before the learned tribunal, praying for reinstatement.
You reinstate them subject to result of the. What is the big deal? Yes.
Sorry.
May I be permitted to mention, my lord? 9 matters are analogous matter, my lord. Today's list 248 to 256, my lord. The matter is the petitioner is going to overage, my lord. That may be taken as a patient.
Overage means for what?
Yes.
What do you mean overage?
Money going to the 50 up there. Their appointment case, my lord. They will any date, any payment, any time may be
No,
fixed.
sir, no upgradations. Something which can't wait till tomorrow, mention that, otherwise let it come. Yes. Inclusion you give. Huh?
Mr. Mushan, my lord, returnable date, my lord, 1st December 2021.
First,
December 2021. 4 times mentioned, my lord. Still now, no listed mention, my lord. Listed mention. December 20.
inclusion next month, monthly list.
But
Yes, which one of you?
praying for upgradation. Well, last week also I mentioned your lordship was pleased to give direction. Well, urgency.
We
is that there.
understand your anxiety, but we would rather go by a system which
Well, only 40
without any
vacancies are remaining in terms of the RTI. If the posts are carried forward, then my application will be infectious. That is the urgency.
Let's see.
Sorry.
Get to item number 65 and 66.
65
and 66.
Yes.
Challenging the order passed by the learned tribunal, my lord. My learned friend appearing for the Union of India has preferred a writ petition, and being agreed by the penultimate paragraph of the judgment and order, original applicants filed the another writ petition. These two writ petition was heard by my lord twice heard by.
No upgradation. Sorry.
Railway authority suffering shortage of staff.
Hmm?
Railway authority is suffering shortage of staff. Goods guard.
Is suffering?
Shortage of staff. Appointment, recruitment is to goods guard of a train.
Yes.
They were
very short matter.
Selected midst of the training.
Let us list all the short matters.
Very short matter.
Yes, all the short matters. Ask your friends which are the short matters. We'll list all of them. Who will say their matter is a long matter? You tell. Yes, call the list.
Any day, my lord. Subject to my
Sorry. Call the list.
Item number 1. Your lordship, I'm praying for short pass over. Mr. Mukherjee is on his way.
Let my learned friend start, my lord, at least.
First case, short pass over. What is this, madam? Don't make such prayers on the first case.
I'm pleading way in this matter, your lordship. On the last, I do agree, your lordship, but
shuru karo.
last is what of the which I'm
Any services? Is there any services still to be affected?
It's not a
service.
Keeping up of way.
I don't know why this envelope is here.
Lordship.
Because of the
Private respondent, your lordship.
They have not appeared.
He never
appeared. His presence was required, man.
He never appeared, your lordship. He was served.
And you are for?
I am for the respondent original applicant.
And I am,
So they were private respondents
there was
also.
a private respondent also,
Yeah.
because, my lord, my plea was before the tribunal that I am the senior in the promotional post.
Your Lordship,
And but I am getting lesser than the junior who joined the promotional post after 2 years. So as per the Honorable Apex Court's judgment, my lord, and I have also relied upon 2 division bench order supports my case in aid for stepping up of pay.
on the last occasion, Your Lordship, Mr. Mukherjee showed the, acha, theek hai, continue.
Only issue. Tribunal granted me the relief.
Tribunal has granted you relief.
Yes.
For that reason, we are over here, Your Lordship. The tribunal has granted him relief.
I
That
have
challenging that.
retired from my service, my lord. But is this when I joined the promotional post in the year 2000?
We have heard this matter.
Yes, Lordship has heard this matter. Lordship, I have relied upon the several judgments.
Your Lordship has, a length it has been heard, Your Lordship, this matter.
Action parallelly.
My notes.
Page 100 the order passed by the tribunal.
Your Lordship, we relied upon the memo of, which we have annexed over here, Your Lordship, the rule. On the last occasion, that was under the.
তুমি বলবেন আমি বলবো তা তুমি বলো
আরে তুমি বলো না यार, আমি যে সিনিয়র কি
আমি তো বলছি তো
তুমি তো তোমার পাটটা বলছো, আমার পাটটা তো বলছো না।
তোমার পাটটা কেন
তাহলে আমার পাটটা আমাকে বলতে হবে।
আমি শেষ।
হ্যাঁ, ওটা তো আমার পাটটা, আমি বলছি। তোমার পাটটা কেন বলছি না ভাই?
বলো তুমি তোমার
হ্যাঁ,
জমা দেওয়া আছে তো
আচ্ছা আমার কাছে ভালো আছে
অল ঠিক আছে
অলরেডি তো জমা দেওয়াই আছে
পিটিশন এনে সেগুলো হাইলাইট করুন
স্টেটমেন্ট অফ পিটিশনের মধ্যেই আছে অলরেডি তো দেওয়া ছিল আগে
My lord, you will have to refresh slightly.
Then
Next Monday.
next one.
Yes, as jointly played list on.
Case our case, my lord, on
Your
Monday.
Lordship, on the last occasion, we had relied upon such documents which were
Just now you are praying for an adjournment.
Yes,
And
Your
now when
Lordship,
adjournment is granted, then you are arguing.
so I prayed for short pass over, Your Lordship, because answer
No, next Monday, my lord.
next.
Under same heading, my lord.
Same meeting, yes.
Your Lordship, kindly make it at 2 p.m., Your Lordship.
No, no 2 p.m. Yes, also we have.
তুমি কেন টাইম নিয়েছো
We have heard this matter.
My lord was passing the order on the last occasion and stopped it in mid and continue with that, dictating the order.
And your lordship, last occasion, your lordship recorded my submission.
Yes. It will pass the order. CAB will pass the order.
Maybe continue with the. Well, as for the read petitioners.
Oh, what's it? Sorry. In 2, 3 and 4. This is not a good call.
4 and 5.
This is the right order.
Item number 3 to 5.
We recorded our submission. Three of them to, this is a concluded matter. Pass the order in this also. We have gone through it, we'll pass the order. List after 3 weeks under the same heading. On that.
আমরা চিফ সেক্রেটারি ফোন করছি কথা
Item number 6 and 7.
Your Lordship, I'm appearing for the appellant. As per your Lordship's last direction, we were supposed to file our written notes of argument. I would like to file it, Your Lordship. May I please?
Written notes of argument has been filed on behalf of the appellant today. Stop matter is made CAV.
Item number 8.
My lord, I am for the petition. My lord.
Yes.
My lord, I am sorry, my lord, on the last occasion, I could not properly convince your lordship about the facts of the case. Today, I will try to assist. Lordship, before going to lordship, kindly just goes to the fact of the case. My lord, then lordship turn to page 66.
Just please wait.
আরেকটা একদম লিস্ট অফ ডিস আছে বার করতে আরেকটা আছে বেটার নয়
Yes.
Yes, my lord. Lord, first I should assist your lordship in giving the facts. The last occasion I was not in a position. I'm sorry for it. Lordship, kindly turn to page 67.
Yes.
This is the chair sheet. If your lordship kindly takes the trouble, the first 3 lines. This is dated 8/10/2004. The undersigned proposes to hold an inquiry against such and such milord under the powers vested under BOD and Rule 14 of the Central Civil Service Classification and Control Appeal Rule 1965. Lordship, kindly note it. This was the initiation of a charge sheet.
Yes.
And Lordship, turn to page 69. Here, my lord, find list of witnesses.
Yes.
Then, my lord, what happened, my lord? After this charge sheet was issued, it was an expert inquiry report. Then, my lord, page 82. Page 82. Straightway comes, my lord. Volume 1. And also, my lords, kindly see the charge sheet was issued by director in charge. First, my lord, director in charge issued the charge sheet. Then, my lord, page 82. Then, my lord, page 82. This was also issued by the director in charge. A memorandum of articles of charge such and such was issued to see Tapos Ranjan Bandyopadhyay. The inquiry proceeding in respect of the said article of charges was held by Dr. such and such, the inquiry officer, and the report dated was submitted by him. By a communication dated 31st/12/2000, the undersigned enclosed a copy of the report of the said inquiry and was forwarded to Tapos Ranjan Bhattacharya for his comments. By this letter, the Tapos Ranjan Bhattacharya has submitted his detailed comments along with a document. The undersigned has considered the papers of the inquiry proceeding, the report of the inquiry officer, and the comments on the report of Tapos Ratu. Since Sri Bandyopadhyay was not present in the inquiry proceeding and since he was subsequently offered his comment on the articles of charge, the undersigned felt it necessary and expedient to remit the case officer for further inquiry and report. Then, my lord, page 83. The order of the Honorable High Court. Thereafter, my lord, page 86. I gave a reply. It is a, since it's a bulk paper, I have handed over, I crave leave. Then next page, lordship, turn to page 87. This final order passed. 9/5/2005.
So before the High Court, you only raised an issue that you will, while remanding it, it should not go before the same inquiry officer.
Thereafter, my lord, page 87.
Thereafter will come after that. What was your case before the High Court?
Yes, my lord.
Only that the inquiry officer should be different, nothing else.
Yes, that's there, my lord. I cannot improve what is there.
No, so you should at least tell us what is there. You are just skipping the page as if you don't want us to see this. High Court only directed to conclude.
Yes, conclude, of course, my lord, in accordance with law.
And if it doesn't say in accordance with law, then it should not be in accordance with law.
No, that's true.
Accordance
That-
with
that's-
law
that-
is nothing.
That's true, my lord.
Yes.
It is implied.
Any time was fixed or just to conclude? Four months. Yes.
Then page 86, lordship, turn to. Page 86, I gave reply to the charges.
Yes.
Then page 87. Nine 5/2005, my lord. This was the final order. Just I read, my lord. Whereas an order of placing Tapas Ranjan Bandyopadhyay lecturer in the department of such and such, one member committee was constituted by such and now whereas on careful consideration of the inquiry submitted by the inquiry officer after giving him maximum possible opportunity to defend himself on the article of charges framed under the undersigned his opinion that charges under article number 1, 2, 4, and 6 made against him stand sustained as such to warrant the imposition of major penalty. Now, therefore, in exercise of power conferred by the Board of Governors of the Institute, the undersigned is hereby orders to impose and see Tapas Chandra Bandyopadhyay, lecturer, penalty of removal from service, which shall not be a disqualification for future employment. Further, the undersigned revoke the said order of suspension. Therefore, my lord, lordship kindly just take a look at who is issuing it, director and disciplinary authority, because I will make some submission on it. This is the.
So this is not by in charge director.
No, this is by director. Issuance by, this is by director. Then, my lord, I preferred an appeal. Next page, page 88. Lord, the appeal was paper on 16/5/2005. Lordship kindly takes the trouble to see point number 7. Just I am reading, my lord. Though the petitioner is not appointed by the director, still, while acting as director, principal officiating annexure A7, the director has not only initiated the departmental proceeding by order number such and also has concluded the same by imposing the penalty of removal against your petitioner, which is against principle of law. Therefore, I should remember this is the first time in appeal this point of was taken that it is beyond jurisdiction. That covers point number 7, my lord. Then, my lord, page 89.
Yes.
Your lordship, kindly too. This is a reply to my RTI, clause 2, page
RTI.
RTI, page 89. Their reply, my lord. Page 89, clause 2, point number 2, my lord. Just I am reading, my lord. Dr. A.C. Ganguly was appointed director in charge by the BOG NIT Durgapur. All subsequent extensions were granted either by the BOG or by the chairman. His tenure ended in May 2005. He was again appointed director in charge by me as chairman of BOG with effect from Atata. Lordship, last line, Lordship, in none of these appointments an extension concurrence of Government of India was obtained.
Why? How is that relevant? You are not challenging his appointment.
And I say, my lord, officiating director in charge, he started. But
Officiating?
as director in charge, he issued the first charge sheet. That's why I am referring it. Facts remain that there was no concurrence of the Government of India. That's why I am submitting, my lord.
What is the date of this RTI?
It is, my lord, 15/9/2005.
Yes.
Then, my lord, turn to page 98. Is the order of the Honorable High Court. Since the appeal was not decided, I was not getting any information. I move this Honorable Court. Page 98. Just I am reading, my lord. Feeling aggrieved by the order of the disciplinary authority, the petitioner preferred an appeal according to the relevant provisions of the rule. During pendency of the appeal, the writ petition has been taken out. Counsel for the petitioner says that the appellate authority heard the petitioner on June 14, 2005. He said that the petitioner has not received any order made by the appellate authority counsel for the respondent is not in a position to say whether the appellate authority has already disposed of the appeal. Needless to say that if the decision of the appellate authority goes against the petitioner, which may also go in his favor, then the petition will lose its utility, and it will be necessary for the petitioner to take out a fresh writ petition questioning the decision of the appellate authority. Hence, I am of the view that the writ petition should be disposed of by giving necessary direction to the appellate authority. For these reasons, I dispose of the writ petition ordering that if the appellate authority has not yet given his decision in the appeal, then after giving the petitioner a fresh opportunity of personal hearing, he shall give requisite reasoned decision dealing with all grounds and contention taken in the appeal within 5 days from the date of giving hearing. If the decision is to be given in terms of this order, then it shall be within 3 weeks from the date of. Thereafter, my lord, next page. After this order, page 100. My lord, this is dated September 26, 2006. My lord, this is the disposal of the appeal after the order of the Honorable High Court. The my lord, order of the appellate authority, just I am reading how the appeals were decided. The instant appeal is taken up by me. The appellant has been duly heard by me. In course of hearing, the appellant pointed out the alleged discrepancies in the proceeding in respect of the order of suspension and the charge sheet dated ato, the ex parte inquiry report dated ato, along with documents annexed thereto, the point-wise replies of the appellant and further report dated such and such. The further report was dissociated upon direction of the Honorable Court to allow the petitioner to present himself before the inquiry authority and to put up his defense, which he did. In the appeal before the appellant has taken number of points. One of such pointers he is not served with a copy of the further inquiry report forwarded to the disciplinary authority dated ato. This is in violation of the principle of natural law. The order of the disciplinary authority dated is therefore set aside, and the appellant would be entitled to make appropriate submissions before the disciplinary authority as regards both ex parte inquiry report as also inquiry report dated such and such filed by the inquiry officer in proceeding, which the appellant has contested. A copy of the second inquiry report is enclosed herewith for Dr. T.R. Bandyopadhyay. The order of suspension revived and shall continue in the meantime and abide by the order that may be passed by the disciplinary authority. Appellant is directed to within 10 days of such order submit his representation before the disciplinary authority. Disciplinary authority shall consider the appellant's representation and therefore, my lord, order initially passed of removal, it was set aside. তারপরে কি আসে তারপরে?
Yes.
Then, my lord, this is the next 101 page starts. I will come to the merit, my lord. Just I am referring the instances how it's conducted. Then, my lord, it is the finding of the inquiry officer. Then, lordship, turn to page 111. This is relevant for me. My lord, this is dated 7th May 2005. Inquiry committee report.
Is your response to the second charge?
Lord, that I will be coming and everything I will be submit. Just let me allow me to place the subsequent happenings was there. Then this is the
Come
inquiry,
to page 102.
page 102.
Yes.
Yes.
The second article, last paragraph. He did not perform his duty as a because there was a debarment from examination duty. Yes, after that.
My lord, after that, my lord. Then, my lord, order of dismissal as page 104.
What is the date of the inquiry report?
Inquiry report, my lord. 7/5/2005. My lord will be getting at page 103.
Seven five 2005.
Yes, my lord. That is signed. That is signed, my lord. That my lord will be getting page 103 bottom. S.K. Chatterjee, Enquiry Officer. 7/5/2005.
So this is before the appellate authority's order.
No, after the appellate authority set aside the order, then Milord de novo, they have passed this order.
Sir, please see the date of the appellate authority's order.
Yes, I have referred, Milord. Just I am giving.
It is 26/9/2006.
Page 100, Milord, page 100.
We are asking you to see the date, not the page number.
26/9/2006.
So therefore, we said inquiry report is before the appellate authority.
Before.
You say no, it is after. This is of May 2005. So which inquiry report? This is perhaps the first inquiry report. Where is the second inquiry report? This is the inquiry report which was earlier considered.
This particular document was forwarded subsequently. That's why I have to annex it. It was not initially given.
But this is not the inquiry report after the appeal. Where is the inquiry report after the appeal? This is not relevant today, maybe. Because after this, much has happened. There must be a second inquiry report. Oh, so this is the first inquiry. After the appellate authority's order, based on the first inquiry report, you made a reply to the disciplinary authority. And then the order has been passed by the disciplinary authority at page 104.
104.
Yes. Is it the correct state of facts?
Yes. Then only Lordship kindly see page 111 for a while. This is the order starts at 104.
Yes. 1-1.
Then, my lord, second show cause notice was issued.
Yes.
In 112 page, I gave a reply to the second show cause notice. Only one thing, Lordship kindly notice, the order was passed by Director, National Institute of Durgapur. This final order was also passed by director.
What is the date? 18/12/2006.
Lord, this is dated October 18, 2006.
18/10/2006. Then you submitted, you are allowed to give, you are given a second show cause.
Second show cause. I replied to it in page 112.
Yes.
Then your Lordship turned to page 126. Starting from forwarding letter was 125, and this is also issued by the director. Dated May 4, 2007. This is also after second show cause notice, final order.
Yes.
Only one thing I will be submitting. My lord, I have tried to submit it. Up to final order, my lord will not find mentioning of any statute in terms of which the proceeding was decided. Admittedly, my lord, I submit the initiation under Central Civil Rules 14. But while carrying the proceeding, I don't find any reference to any particular rule. And another thing I would be submitting to your lordship, that my lord will not find that any presenting officer was there and any witness was examined, though referred to.
But you have not denied the charges. You have admitted to the charges.
I never admitted, but that I'll be showing. Just I'm showing how they have. Then
You
then
have,
I
you
will
have-
come.
rather you have
Will
tried to
absolutely-
justify why you have not complied with the orders.
That I will be submitted. Before that, lordship, allow me to just go through how
Because you are raising an issue regarding there being no presenting officer, unless an issue is to be established. When you say that, no, yes, I have not done this, but I have not done this for this reason.
I vividly replied that I was not at all responsible. They relied upon some witness. They referred some witness.
You have never said that you are not responsible. Show us.
I show me lot. I'll
Show us
I'll
where you
show,
have
just me lot. Allow me to just go through ultimately. Then I will come to this merit point, my lord.
You say
Certainly
I have
have
not
to
set the papers because of this reason. You say I have not examined the papers because of this reason.
Yes.
You don't say that I have set the papers or I have examined the papers. You say I have not done it.
No,
I will
could
not do it
my lord.
because of these reasons.
Lord, I say, my lord, I could not. That how can I say I have had it been a case, I have examined, I have set the papers, question of disciplinary doesn't arise.
Therefore,
my lord, under what context I could not do it, that I will come to your lordship.
no, it's not could not. We are going through it. That's why we are asking. It is not something preventing you. You are saying that because of these reasons, I will not do it.
Yeah, I could not, my lord. It was not possible for me.
No, that you have not said.
That I will coming just for a while because subsequent happenings is there. Lordship,
Yes.
allow me to go through subsequent happenings. Then I will certainly bow down to your Lordship observation. I will reply every questions to your Lordship. Then, my Lord, what happened? Page 145.
Yes.
Then appeal
What
That-
145?
145 of
What
the
is
paper
this?
book, my Lord.
What is this?
This is-
145?
Yes, my Lord. Proceedings of hearing of the appeal. The appeal I preferred has been ultimately decided.
No, after the disciplinary authorities
I
order.
preferred appeal I showed to your Lordship. And that has
112.
Yes.
Where is the appeal? After the disciplinary authorities order, again you have filed a writ petition.
Yes, I filed a writ petition, Honorable Court. Last paragraph 137. In view of the above, the writ petition stand dismissed as withdrawn with the hope and trust in the event any appeal is preferred by the petitioner before the appellate authority with regard to the aforesaid order dated May 4, 2007. Same will be disposed of by the appellate authority within 2 months from the date. That was the order of the Honorable Court. Pursuant to thereto, at page 145, the appeal preferred by me was decided.
Where is your appeal? You are not annexed your appeal.
This appeal was by the retired person. This appeal also set aside by the Honorable High Court. That I am showing. This appeal preferred by me, which I have shown, decision of the appellate authority has been set aside by the Honorable High Court. That
But your appeal is not there.
I appeal preferred. That's why decision is taken. Memo is not annexed, my Lord.
So we are asking you
Yes,
so many
memo
times,
is-
why
memo
don't
is
you
not.
tell us? Yes.
Page 145. Then
What is the date of this order?
Date
4/5/2008.
13/8/2008. Page 150, my Lord. And Lordship only think this appeal was decided by a retired professor of electrical engineering, former regional engineering college.
Yes.
Then Lordship kindly turn to page 159 first. The director of the institute ordered removal of the petitioner from service. The said order was confirmed by the Board of Governors of the institute. In terms of the discipline and appeal rules governing the institute, Lordship kindly marked it in terms of discipline and appeal rules governing the institute, the Board of Governors ought to act as appellate authority in respect of an order of penalty passed by the director. However, in the instant case, since the Board of Governors had confirmed the order of the director, the appeal filed by the petitioner thereagainst could not be considered by it, and hence he was placed before a retired professor of the institute for consider. The appeal was rejected in the order of removal. There has been lots of kindly 158. Kindly, it has been some problem here. 158. Mr. Have you also got it? Mr. Banerjee, learned advocate for the petitioner, contends that in view of confirmation of the order of removal passed by the director of the Board of Governors of the institute, the appeal of the petitioner ought to have been placed before the visitor, being the President of India, in terms of the rule. Having heard learned counsel for the petitioner and the learned counsel for the institute, the contention raised by the petitioner appears to have sufficient force. The institute could not have placed the appeal before a retired professor of the institute for the purpose of his disposal. In all fairness, the institute should have placed the appeal before the visitor in terms of discipline and appeal rule. The appellate order upholding the order of removal stands set aside. The institute shall now place the appeal of the petitioner before the visitor for his disposal in accordance with law. Then, my lord, I kept on approaching the authority for disposal of my appeal. I have annexed all the things. I sought for RTI Act. What is the state of the appeal? Nothing was informed. Then Lordship turned to page 185. Then, since the appeal was not decided, which is supposed to be decided by the visitor in terms of court's order, Lord, I have to again move this honorable court in page 185.
This is MAT is filed in the earlier writ petition.
Yes, my lord.
This seems to be against some order, appeal order. Against which
Appeal order, my lord, since the writ court did not fix a time limit, I moved the division bench for early disposal of the appeal before the visitor.
So against 15306.
Yes, yes, that's what.
Yes.
Just I read page 185. This application has been filed in connection with the appeal preferred from a judgment and order dated 23rd September 2009, passed by a learned judge of this court, whereby the said learned judge allowed the writ petition on merits. The appellant herein, being the writ petitioner, preferred this appeal, being aggrieved by non-fixation of time limit of the learned single judge for disposal of the appeal of the writ petition by the visitor. Going through the order under appeal, we find that the learned judge directed the respondent institute to place the appeal of the petitioner before the visitor for disposal in accordance with law. The learned advocate representing the institute submits that appeal of the petitioner has already been placed before the visitor. In the circumstances, we request the visitor to take necessary steps so that the appeal of the petitioner is disposed of in accordance with law at an early date, preferably within a period of 2 months from the date of communication of this order. With this aforesaid observation, the appeal was made.
So only time limit was
Yes.
added.
Yes, yes.
Time limit was added to the order passed.
Added.
Yes.
Then, my lord, what happened? Admitted position, my lord. Admitted position. From here I start, my lord. The appeal to be decided by the visitor. Facts remain, I was not called for. I had no opportunity to contest the appeal by making any submission before the visitor.
Where is the requirement?
Requirement means natural justice. Natural justice said, I have preferred an appeal. If it is hard, I can say something, I can substantiate my case.
We are asking you, where is the requirement? You said that it has been conducted under the CCS.
Yes.
In the CCS, appeal is to be placed before the visitor.
This is my submission. Initiation CCS rule. But ultimately they filed, I will show from the reply, they say CCS rule is not applicable.
No, because perhaps thereafter the NIT has been declared as an institute of excellence and it is governed by the new act.
No,
Under the
new
new act, visitor will
new
be
act
the
came-
competent
new-
appellate
right,
authority.
New Act came into force, NIT Act 2007.
Therefore,
My lord,
correct.
proceeding cannot be made under 2007 because order of
No, but at the time the writ court was passing the order in 2010, it was the visitor who was the competent appellate authority and therefore a direction was issued to
Yes,
place
yes.
before the visitor.
Yes.
Now, under the NIT Act or the act under which it has been declared as an institute of excellence, where is the requirement that appellate authority visitor will hear the person? Show us.
Visitor did not pass any order. That is my question. Had it been a case, visitor
Now,
passed.
when we make one submission, we ask you how you are saying, then you jump to the next point.
No, 2000, NIT Act. NIT Act 2007.
You said I was not heard. Principle of natural justice. We are asking you, where is the requirement that even at the appellate stage, when the visitor is passing the order, you are required to be heard.
Right, let us examine NIT Act 2007.
You have to. You are making submission. There must be based on the NIT Act.
No, my lord. I candidly submit in 2007, I find no specific statute to the effect that appeal in person to be heard. That is
All
not
right.
there.
So then what is the next point?
Next point will
That the visitor did not pass the order.
Yes.
That is your next point.
Yes, next point.
So what does the rule say? What does the act or rule say? Let us see. That visitor is personally required to pass an order. Where is it? Let us see. Show us the act.
The lordship just for just I'm coming to how it happened. I should show page 250.
How it happened means what happened?
Communication after the visitor, it was referred to the visitor. I received a communication from the authority, joint secretary, at page 250.
What is it? That your appeal has been decided.
This has reference to such and such addressed to the President by the CBN Rai advocate regarding implementation of order of the Honorable High Court. Institute, having regard to the fact that Honorable High Court has directed the appeal of the petitioner before the visitor may be disposed of expeditiously and preferably within 2 months for your expedition, a copy of the appeal as received, then they are forwarding it. Forwarding the appeal. Then my lord inquired me about whether you have taken this point. Page 207.
Taken which point, sir? You have
Points of jurisdiction, my lord, on the last occasion.
Why do you move from one point to the other without addressing the? You just now said that it is not passed by the visitor. We ask you, where is that provision? Now you are going to another point. Where is that provision that the visitor is personally to pass the order?
That provision is not that. Appellate authority appeal to be preferred with the appellate authority will decide the appeal. That is there.
Yes. No, because
an appeal to be preferred by the appellate authority will decide the appeal. That is there.
Correct.
Whether the visitor can delegate to someone.
So where is it? You have seen it, therefore we should take it. Show us. Where is it?
A appeal to be decided by the appellate authority.
Where is the provision, sir? The appellate authority, you know who is the appellate authority? Who is the visitor?
Visitor is the appellate authority.
Who is it? Which official is the visitor?
Lord, court said visitor to be decided. Visitor is the appellate authority in the instant case.
Visitor is the President of India.
my lord,
So therefore, the President of India is required to personally pass the order. Let us see the provision.
it is not there. I cannot say.
All right.
I
So
cannot say
that is also not
President
there.
of India has to pass it personally.
But
It is
that
not
is,
there.
you just now you submitted, therefore we are asking.
I
you.
say, my lord, appellate
Yes.
authority is to decide the appeal. That I
All
say.
right, all right.
I cannot say, my lord, the statute saying that if it
All
is
right,
placed
now
before the visitor,
then what
visitor cannot
is, so
take.
these 2 points you are not saying, then what is the point?
Then page 215, my lord.
Very well.
I
Then,
am, I am directed to refer you later dated on the above subject and say that in appeal proposal of Taposh Ranjan Bandyopadhyay, ex-faculty member of the Durgapur, was taken up with the Honorable President of India being such and such visitor, has informed that the President of India, in her capacity of the visitor of the National Institute of Technology Durgapur, has been pleased to approve the proposal of the MHRD contained in para 3 of the summary, in which is reported the Minister of Human Resources has recommended that appeal proposal needs be rejected by an order dated for the discipline.
yes. So appeal rejected. Then what did you do?
Therefore, my lord, I show to your lordship, MHRD department has proposed for and on this particular proposal has been accepted. Page 279 of the paper book, volume 2. What was the proposal of the MHRD department? Because as said, President has simply accepted the proposal. Where is the consideration, my lord? Even assuming for the argument said President in the capacity of President cannot decide the appeal, he might have delegated it to for his consideration to some authority. On that, the President accepted. But then page 279 of the appellate authority order kindly sees where is the consideration. Subject. Consideration of the appeal of Dr. T.R. Bandyopadhyay, ex-faculty member of National Institute, filed by him against the order in respect of the disciplinary proceeding under charge sheet dated in accordance with NIT Act 2007 and the first statute forwarding necessary proposal thereof. My lord, here it is mentioned in accordance with NIT Act 2007. That is not the fact about. At that material point of time when the proceeding was initiated, final order passed, NIT Act.
Where is the letter from the President's Secretariat dated 21/10/2010?
This is a inter-department, this is not with me. It is inter-department. President has forwarded it. It cannot be with me, my lord. President Secretary has referred it according to them.
So you have page 215, but you don't have the enclosure with page 215.
No. This has been subsequently, I've got it, that on this particular recommendation of the MHRD department has been accepted.
Read page 2115.
210.
215, you were just placing 215. You say there is no consideration. Whereas that order reads that there is a consideration which is contained in the Secretariat's letter dated 21/10/2010, and that is enclosed with this order.
115, Lord, I'm just. No, my lord. Simply this was given to me.
You have said so, that this enclosure was not given to me. Where have you said? Let us see.
And subsequently, this has been, that I have sent, this has been made from a reply. I have got it. I have got it subsequently. That is 279.
You have got what?
You know, 279 is a proposal of MHRD department to the president.
We are asking you something else. You are saying something else.
Yes.
Page 215. Please read the first paragraph at page 215.
215. Director, subject WB, filed by Sri Taposh Ranjan Bandyopadhyay in the High Court at Calcutta regarding his removal from service or consideration of the appeal by the visitor regarding. I am directed to refer to your letter dated 14/9/2010 on the above subject and say that the appeal proposal of Taposh Ranjan Bandyopadhyay, ex-faculty member of NIT Durgapur, was taken up with the
Taken up by the, now read slowly.
taken up by
Yes.
the Honorable President being the visitor.
For NITs.
CACA copy enclosed.
Huh?
Secretary by note that
Why are you skipping one line, sir?
as in that the President of India in a capacity of visitor National Institute of Durgapur has been pleased to approve the proposal of the MHRD contained in para 3.
The President, why did so and so, dated so and so, copy enclosed? Where is that copy? Why you have not placed that copy? We are asking you.
No, this is not given to me.
So you have said that this is given without the copy. Where have you said? Let us see. How have you enclosed this? From where have you got this? 215.
Was my lord. Immediately the order was passed. They directed me to vacate the quarter and followed by which on 214. This was a part of letter dated 11/11/2010. By communicating that, they directed me to vacate the quarter, and that was this has been a part of this.
So where have you said that it was this? This was not given to me.
I said, my lord, that by directing me to vacate the quarter, this particular document was annexed with the letter. That whereform I have got it.
So therefore, it was incomplete. Where have you said it was incomplete? Or why should we not ask you why you have suppressed this?
I have not suppressed anything.
So therefore, show us that you have said that this was given to you incomplete. The copy was not given to you.
Copy, my lord, this is the communication only given to me.
Why are you suppressing things?
No. Why do I suppress, my lord? I
please-
say, my lord, this particular doc, I have annexed it.
You are
They have
saying that
given the reply.
you are saying there is no consideration.
Yes.
At page 215, they say that the president has considered and the copy is enclosed. In the bottom also it says copy enclosed. See page 215.
This is the 270.
Please see page 215.
The Minister of Human
See what does it say at the bottom left hand side?
He requested that necessary action may please be taken.
Bottom left hand side, enclosure as above.
It was not given to me.
So therefore, where have you said that it was not given to you?
They have said a proposal of MHRT contained in para 3 of the summary which is held. The President has accepted it. Lordship, the proposal of MHRT has page 279.
All right, then we take it that you have suppressed.
No, Lordship cannot take
Then you
it.
please show us that you have said that this was not given to you. In para 1, the President's Secretariat letter is mentioned. The letter is received from the President's Secretariat. It is dated 21.
I acknowledge that.
21/10/2010. Read it.
Yes, I
And it says this is enclosed. Why
It
have
was-
you not enclosed it?
It was not given.
So therefore, where have you said that
This
it was not?
particular content is in para 279. Lordship, I
Let us
see.
see. 279, you have said that it was not given.
279, this MHRD recommendation which is accepted by the President.
We are not concerned with MHRD recommendations, sir. Either you are, we don't know what to say.
Yes.
We are asking you to just have a look at first paragraph of page 215. Before we conclude that you have suppressed, we are giving you the opportunity. Therefore, we are repeatedly saying it. Page 1, paragraph 1 says that the President's Secretariat letter is there showing consideration. Still, you have not enclosed it. And you are saying that it has not been considered. Therefore, we are asking you whether that document was given to you or not. What is your case? Either you would have said that it is not given to me, or why have you not annexed if it was given to you?
It was not given to me.
So show us that you have said it was not given to you.
Lordship, kindly. Page para 46, how I have dealt with. Para 46 of page 43 of my volume.
43.
Exactly answered I have given page 47. Paragraph 47.
Page 47.
No, page 43.
Yes.
The referred annexure dated, my lord has referred.
Yes.
I am just referred. Page 43.
Yes. Yes.
Your petitioner says that thereafter Dr. A. Gandopadhyay, register in charge, such and such, enclosing, issued a letter dated enclosing the photostat copy of the memorandum dated under the signature of here it is quoted. Photocopy of the letter.
Which page you are reading, sir?
Page 43 of my paper, volume 1 paper book.
Yes.
This is with reference to the memo my lord has.
2910.
Yes.
Yes.
This has referred. How I have got it? I preferred and I mean, I waited for it. I sought for its order. I number of representation at TIX.
We are only asking you to clarify whether you have received that letter of.
Yes, page for your petitioner said that on receipt of such communication, paragraph 47, your petitioner on November 9, 2010, by fax message brought into the notice of the visitor, also see A.K. Singh, such and such, that neither the petitioner has been served provided with any order of the appellate authority of the visitor, nor the proposal of the MHRT for rejecting the appeal.
Where is this 1911-2010 communication, which you are referring to in paragraph 47?
Page 34. This is the communication in terms of which they have referred the president's order.
Where is this, sir?
Yes,
P35. Where is P35?
P34, below.
P35. P34 and 35 both. We'll have to see. P35 is 216. P35 is at 216.
Is the forwarding letter is 11/11/2010. And this is, my lord, New Delhi, 29th October 2010, page 215.
It seems like.
And also, my lord, this has been stated by in paragraph 47 also.
No, in paragraph 47.
Yes, I read, my lord. I read, my lord.
There it is ambiguous, here it is clear.
My lord, that neither the petition has been served provided any order of the appellate authority visitor, nor the proposal of the majority. That is categorical statement in paragraph 40.
Here it is very clear, yes.
Yes. Then, my lord, my submission was that admittedly, my lord, visitor is to decide the appeal. Even assuming, my lord, visitor has delegated someone to decide the appeal in a manner, then here is a case I showed, my lord, no independent order of the visitor has been supplied to me. What is there recommendation of the MHRD at page 303 has simply accepted. Their lordship kindly takes the trouble to see page 03.
Two zero three.
303, my lord, of volume 2 of my paper book. This is the proposal of the MHRD, which has been accepted by the visitor, my lord, as communicated to me. My lord, I am reading, my lord. President Secretariat subject consideration of the appeal.
This is the enclosure. This is the enclosure to page 215.
Yes, before that, my lord.
You said you don't have it. This is the enclosure, 21/10/2010.
Yes, 298. I'm sorry, my lord. I'm sorry. The jumble of facts is there sometimes.
You are there to unravel these things.
I'm sorry. I'm sorry.
Yes.
Lord, is helping me, Lord. I'm sorry. Page 298. Government of India, Ministry of Resource Department, Department of Higher Education, Technical 2. Subject, consideration of the appeal of Dr. T.R. Bandopadhyay, ex-faculty member of the National Institute of Technology, Durgapur, filed by him against the order in respect of the disciplinary proceeding under charge sheet dated 8/10/2004 in accordance with NIT Act 2007. Lordship, kindly notice this. They are admitting it when NIT Act came in 2007, and much before that I have been dismissed, and the first statute forwarding necessary proposal thereof regarding President Secretary memo number statutory provision. The para 26, 9 and 10 of the first statute, Annexed 2, under National Institute of Technology Act 2007 reads as follows. Enter consideration. A member of the staff agreed by any order imposing penalty passed by the director against him shall be entitled to prefer an appeal to Board of Governors against the order, and there shall be no further appeal from the decision of the board. A member of the staff agreed by any order passed by the board inflicting a penalty on him shall be entitled to prefer an appeal to the visitor against such order. Briefcase. The disciplinary proceedings were initiated against Dr. Tapos Ranjan Bandopadhyay, ex-faculty member of the National Institute of Technology, Durgapur, on the basis of the charges in connection with his failure to do his duty in setting up of question paper, evaluation of answer sheets, return of answer sheets without checking, handing over of secret documents to the press to make it public, where the documents contain name of the paper setter and examiner, and for trying to jeopardize the whole process of examination, where the fate of undergraduate, UG, postgraduate, statute of such and such, detailed charge sheet. 2. The inquiry committee concluded that Dr. T.R. Bandopadhyay has been found to flout deliberately the basic duties of a teacher. He is found guilty of charges as expressed in the articles of the charges. Such and such. Dr. Tapos Bandopadhyay was removed from service as per the following order dated 4/5/2007 of the disciplinary authority. Dr. Tapos Bandopadhyay is hereby removed from service if the institute, the period spent on suspension, shall be treated as such and shall not be treated as on duty. A history of the case is chronological order is attached, Annexed 2. After a prolonged litigation, the division bench of the Honorable High Judicature at Calcutta ultimately requested, by judgment dated such and such, the Honorable President of India, being the visitor, to take necessary steps so that the appeal of the petitioner against his dismissal from service is disposed of in accordance with law at an early date, preferably within a period of 2 months from the date of communication of the order. This ministry has received a copy of the proposal such and such, Tapos Ranjan Bandopadhyay, along with documents the charge sheet, the reply of the appellant and his appeal, etc. from the institute. In the meantime, the institute has also requested to get in touch with the Assistant Solicitor General in the Calcutta High Court so as to pray before the Honorable Court for extension of time in order to implement the order dated at the recommendation of the Minister of Human Resources. The Minister of Human Resource Development has recommended that appeal proposal need be rejected and the order dated 4/5 of the disciplinary authority Durgapur may prevail. According to the proposal of NIT Durgapur on the above subject is forwarded herewith for consideration of the visitable as requested by the Honorable High Court, Calcutta. The proposal of consideration of appeal may be placed for consideration of the visitor for his order. There is no consideration, my lord. Not a single sentence, my lord, will be finding from the order is there was any consideration of any appeal. Whatever people
This is not a consideration, this is a proposal.
that
Along-
proposal has been accepted.
Along with this proposal, the entire document has been sent. You
And-
see the first enclosure at page 302.
Yes.
At page 302, the first enclosure.
And this proposal has been accepted. So where is my consideration of my appeal, my lord?
All right. So no reason is given for.
No reason, in fact, there is no consideration even. Not even
Obviously, therefore, no reasons. No reason means no consideration.
my submission would be before, but my appeal was not at all considered.
Yes.
I have a right to prefer an appeal.
Yeah.
I preferred an appeal. And it is simpliciter a recommendation. And this recommendation has been in toto, has been accepted without any consideration of
Where
appeal.
is the appeal procedure in NIT Act? Let us see. NIT Act 2007.
I have given my lord last week.
Which is the appellate provision is? Disciplinary rules has been framed by the for any authority under the NIT Act.
Lord, even this act is not applicable because my order of removal is much earlier. How they can make and not even that my disciplinary proceeding was not decided under NIT Act when the NIT Act was even not even born. I showed to your lordship charge sheet under classification rule. They have admitted in page 235A, lordship kindly sees which act to be applied. Page lordship kindly see, page 235A. Page 225.
the appeal? Are you abandoning that point?
No, no, I am
Then
not.
where is the provision for appeal? Why don't you show us? The moment we ask you something, you go to another point.
Provision of Millard 26 says suspension, penalty, disciplinary proceeding.
Where is this?
This is NIT Act. NIT statute. First statute of NIT. I have given Millard copy. Have you got it? I have given Millard a copy statute.
The next is some trading.
I am reading.
Just a minute. Yes. Starts from which page? Page 14.
What acted under statute which is
Not what is referring. You are referring to which statute?
This statute has been framed in terms of National Institute of Technology Act 2007, in terms of which this statute has been framed.
And is
And
the name of the statute? Where is it? You have given us separately, or it is part
this
of the
statute may be called the first statute of the National Institute of Technology. But I have got 2 copies, Lordship kindly seize it on 26 onward. Huh? 1 copy. Lordship, I have got 2 copies. 20 in the Joshua. 26 onwards, Lordship kindly. उपाय नहीं हम जज के देखा था देखते देखते
Yes.
Yes, Rule 26 onward, I have got, I find personally I have no copy at which I have got 2 copies I have given. Therefore, my lord have seen. I have shown the entire documents before to your lordship up to the decision of the appellate authority.
Does this say that the visitor is the appellate authority?
Yes. In case of staffs, my lord, staffs, in case of academic staff, visitor.
So this is like a second appeal against the disciplinary authority before the Board of Governors and then before the visitor.
Lord, this consideration by the visitor was pursuant to Honorable Court's order. Honorable Court directed that visitor to decide the appeal.
Yes.
That's why, my lord,
Because the Board of Governors had already applied its mind.
yes, my lord. That's why, my lord, visitor to decide the appeal. My submission would be, my lord, if visitor is to decide the appeal, even if it is been delegated to someone, whether any consideration of the appeal at any, there is no consideration of appeal.
Yes.
Number one, my visitor himself did not pass in order. Even the MHRD proposal is not in consideration of appeal. It is a simplicity recommendation of papers were sent, but no decision was at all taken in the appellate authority order.
Yes.
And my second submission would be before your lordship. Lord, admittedly, my lord, this particular NIT Act 2007 has been applied in my case. And I have showed the recommendation, the first line says, they have taken a decision or they have referred the proposal referring to NIT Act 2007, which in no sense can be applied in my case because if not, my order of suspension followed by charge sheet and ultimate order of termination was much earlier the NIT Act or NIT statute came into force.
So according to you, who should have been the appellate authority?
Now, the appellate ought to be pursuant to order of the Honorable Court visitor, but I cannot go beyond the order of the Honorable Court. Honorable High Court said that visitor to be decided.
Yes,
And
so what is the issue regarding the non-applicability of the statute that we are not able to understand?
my interpretation, even if this particular NIT Act came into force after subsequently, my lord, in 2007.
No, in 2009.
2009.
Yes.
Whereas my order of termination is 2004 or 5.
So
therefore, my lord, this particular act cannot be applied, even if it is applied.
Not be applied for what? For the appeal?
Because my proceeding was initially initiated according to them under the TCS rules. Then, my lord, subsequently, my lord, they have, I will be showing 235A, lordship, can you see? The Delhi IIT rule would be applicable in my case. List of guest কবে dismiss করছে list of guest আরেকটা list of date রাখা আছে
Yes. Yes.
Therefore, my lord, my submission, what would be the rule to be applied in case of my disciplinary proceeding followed by termination and the appellate authority? I have shown, my lord, to your lordship, first, they have director had issued a order of termination in 5 following civil central appeal rules, which then lordship kindly turn to page 235A.
At least to me, sir, it is not clear, speaking for myself.
Yes,
You are raising the issue of there being 3 rules applicable at different stages of time.
they have applied.
Now you are saying this will not apply.
They have applied, my lord. They say they are. That is my question. I am not saying, my lord.
Please hear us for a minute.
Yes.
We are trying to understand.
Yes.
This is an act which has come into force in 2009.
9.
After this, the appeal has been considered.
Yes.
According to this, the appellate authority is the visitor.
Yes.
So how does this not apply?
For the purpose of appeal.
Yes.
Yes, for the purpose of appeal, when the act came into force, visitor.
Applies?
Yes, applies.
Now for the purpose of charge memo, how can it apply? Charge memo was under earlier rule.
Yes.
So therefore, who says for the charge memo this applies? Is anybody saying that this applies for the charge memo also?
No, they say, my lord, according to charge memo under civil central rule. And they, by filing reply, say, my lord, I am just reading page 235A.
What is it? Tell us.
It is denied and disputed that Rule 22 of the CCS Rules 1965 have any application in the facts of petitioner's inquiry is governed by the IIT Delhi rule as has been annexed.
Yes.
Therefore, my lord, according to their submission by reply, they say, my lord, that though it was issued under the civil central rule, it is not applied. It cannot be applied. IIT rule is applicable in case of petitioner. I am not saying, my lord. I am what is there in the charge sheet. I have just referred to.
All right. Tell us your submission. What are your submissions?
Now let us come to, my lord. If it is under CCS rule, who would be the appointing authority? Appointing authority must be the disciplinary proceeding under the CCS rules. I refer, my lord. If it is under CCS rule, then appointing authority would be the disciplinary proceeding.
We are not aware of any procedure where anybody lesser than the appointing authority is the disciplinary authority. It is a settled law.
Yes.
Whether CCS, Delhi IIT Act or this NIT Act,
And this
everywhere the disciplinary authority has to be someone who is the appointing authority or above. Or above.
Yes.
Therefore, there can be no distinction in these 3 rules on that aspect.
I bow down to you. This is my first submission.
What first submission? There is no distinction. So therefore, what you have to show us is whether the person who has issued the charge memo was not your disciplinary authority.
Yes, that I am showing.
So show us.
Yes. Lordship kindly turn to charge sheet.
Yes.
Page 64. Page 66. Who has issued it?
So director in charge.
Director in charge.
All right. Got it.
And final order. By the director.
So he is also not competent.
He is not also the competent.
So charge memo as well as the final order both issued by incompetent authority.
Okay.
What else?
Therefore, my lord, not being appointing authority, he cannot initiate a disciplinary proceeding.
But you never objected to this.
I objected to by preferring an appeal.
In the appeal for the first time.
My lord. I preferred it, but this is a question of law. A question of jurisdiction.
Yes. What else?
It is a question of jurisdiction. Whether number one, regarding my lord,
Yes.
no presenting officer, non-examination of any witness, charge framed, decision taken.
Yes. Yes.
Third, my lord, applicability of not exact rules. Why I say, my lord, according to them, initiation CCS rule is not applicable. According to their own affidavit, Delhi IIT rule is applicable. It was not followed. Ultimately, appellate authority order I have shown is absolutely non-speaking, no reason, nothing of any, no decision. Neither it speaks of any consideration nor any reason. And even the application of the act, my lord, considered by act which did not come into force. Then, my lord, in this respect, my lord, the first, I will refer my lord's decision, my lord dealing with the case in
What is the issue regarding inapplicability of the act? It is not clear, sir. Please. It is not clear. You refer to three acts, three different names of the act. Which act is not applicable to which portion of the inquiry? How it does not apply? You are not saying anything. You are saying not applicable. What does that mean? The charge memo was issued under CCS.
Yes.
You say by incompetent authority.
Lordship, and it takes the trouble to see CCS rules for a while.
Yes.
CCS rules, Lordship.
Yes. What does it say?
I have
What aspect is it that you are relying upon?
rule clearly says,
Yes.
referring to Article 311,
Yes.
that not being appointed, it has to be done.
That is already that you have argued.
Yeah.
So
Therefore,
it is uniform in all the three acts.
Therefore,
This is uniform in all the three provisions. There is no difference.
Therefore, my lord,
Which of these three provisions?
I have been appointed.
Which of these three provisions says that a person below the appointing authority can be the disciplinary authority?
No, never said.
Then why are you raising this unnecessary issue that this act does not apply this statute? It is common.
My case is most simply, my lord, not being an appointing
All right,
authority.
that is all. So you again, now what is the other point?
Then, my lord, second point, I wish to refer one judgment of my lord.
Yes.
But where my lords in dealing with a similar matter,
Yes.
had dismissed a disciplinary proceeding on the ground.
Let us see.
আরেকটা এরপরে কি আছে এরপরে কি বলেছে Yes, Pilot. তুমি কটা আছে রে? হ্যাঁ দিচ্ছি হুম হ্যাঁ আমরা ওকে দিয়ে দিই কেন তো judgment of factor goes into root of the matter ওই বাঁচিয়ে আছে Now my lord has asked me on question why did you not raise this question and even if I did not raise the question yes I have my lord if it is a reasoned order it's
That also of another high court. Are we bound by this judgment in any way?
I am not sure. I am referring to your lordship consideration. My lord has considered it in a judgment, my lord.
Anything
I have
else?
searched it.
Anything
I have
else?
searched it. On this point, I have found my lord has while in Patna High Court, my lord has dealt with so many service matters.
Whoever it may be, sir, it remains the judgment of a single judge, which is being placed before a division bench, and that
It is
also a
not,
single
my lord,
judge of
my lord,
another high
to
court.
my little knowledge,
Yes,
it is not
anything else?
it is not necessary, my lord, single judge judgment is not binding. I am not saying it is binding.
Yes.
I say, my lord, in a similar situation, has dealt with. I have searched it. I have found
Anything
it.
else? Anything else?
Now, my lord, on one question, my lord has put up a question. Why did you not raise this question? Even if, my lord, if I did not raise this question, it is a jurisdictional error. In that score, my lord, whether my lord will decide it. That
There have been 3 writ petitions in the meantime.
yes.
3 writ petitions
Yes.
by you. In none of the writ petition you have raised this issue.
But in the appeal, I have raised it. In appeal, I have
So
raised it.
We'll see. Yes.
But
we
in
will see.
appeal, I have shown to you. In appeal, I have
Yes.
raised this particular point.
Yes.
In precisely and the memo of appeal, it was a ground.
Yes. Anything else?
Yes. Lord, one judgment I'll be referring, Lord. This is 1991 SCC, page 193. 1991, SCC 193. Just I'm giving a copy, my lord. Before that, I'm just reading the line. A decree passed by a court without jurisdiction over the subject matter or on other grounds, which goes to the root of its existence of jurisdiction, lacks inherent jurisdiction. It is a quorum non judice. A decree passed by such a court is a nullity and is non-est. Its invalidity can be set up whenever it is sought to be enforced or is acted upon as a foundation for a right, even at the stage of execution or in collateral proceeding. The defect of jurisdiction strikes at the authority of the court to pass decree which cannot be cured by consent or waiver.
Very well, give us a copy. We have understood. Give us a copy. Which paragraph you are relying upon? Tell us. Where are the copies?
I'm giving copy. I'm just keeping them, Lord.
This is the way to cite a judgment. You are reading for yourself. You have not given us copies.
I'm giving. I'm just giving.
Just give us copies and tell us the paragraph number. That's all. Please move to the next point or next judgment, whichever you want to. We can't wait all day for you, sir. Please give us where is the copy and tell us the paragraph number. What are you doing?
2013 is SC 479. Paragraph 27.
This also you will give later.
Yes, no, but I'm
Everything you read and then you give us later. Wonderful way of arguing a case. We should not see what were the facts of the case, in what context it was passed. You read a paragraph and then you say, I will give the judgment later.
Paragraph problem is that online subscription sometimes is not telling. That is the problem that we are facing, Milord. We are getting it from
Ultimate
online.
problem you will face also. You are citing a judgment referring to a paragraph, and from the report, if it is different, then also you will suffer the problem.
That's the problem is there. Online we are
expecting you to be conscious of this requirement. How are you proceeding? It's becoming impossible to consider your case. And this is the fourth day we are grappling with this issue. Because of the way you are presenting it, is incoherent. We don't know what to do.
Online copy.
Give us a copy, sir. What are you doing? Online copy and this copy, that copy. As if we are in a casual conversation here. Again, I will. Sorry, sir, we can't wait all day. Again, today is time more than an hour. You have wasted like the last day. Same thing happened last day also. You proceed and then you get stuck and then it is impossible to proceed further. put up a further hearing after 4 weeks.
No, Lordship,
Do
kindly.
whatever you want.
No, Lordship, kindly give. Tomorrow I will give all the citations below. Tomorrow I will give. Tomorrow I will give
Call
all
the
the
next
citations.
case, sir.
Lordship, kindly, tomorrow I will give all the citations. Lordship, kindly take me amiss. Tomorrow I will give all the citations. Keep it tomorrow. I will give all the citations. Just for the citation, nothing left, my
The
lord.
saying goes as patient as a judge.
No, I'm sorry.
That
my
is
lord.
also
No, my lord,
subject to some
keep it
limitation.
tomorrow. I will give all the citations
case, sir.
and matter will be ended. My lord, Lordship, kindly don't kindly make it 4 weeks. My lordship, kindly give it any day. I will give the entire citation one by one, and my lord will finish it. My lord have heard it. Lordship, kindly feed.
Item number 9.
Lordship, kindly I beseech to your lordship, take it on tomorrow or any other day, Monday.
Who is in the next case?
Lordship, kindly see fix on Monday. My lord, I beseech to your lordship, take it on
We have considered. Yes, next case.
without 4 weeks. My lord, fix it on Monday. I will give all the citations and my matter will be ended.
You are appearing. Who is? Come in the next case. Who is appearing?
Lordship, kindly hear me, my lord. Take it on Monday or any other day. I will cite the judgments only, nothing more.
Yes. We are directed for the records to be called. Not received.
Not received. There is a direction upon the respondent also to pay the special messenger cost.
I have not done.
I am not sure that whether I am for the appellant, my lord. There is a direction upon the respondent
Yes.
to pay the special messenger
Has the
cost.
special messenger cost been deposited? Should be there in the. Where is the respondents' council? The respondents' council is not present.
Item number 11.
Why this has to be modified? What happened?
I am not asking for modification. Lordship will kindly see the order once, my lord. The paragraph they are mentioning, my lord. Perhaps, my lord. Yes, it's his application. So
It's my application while I'm pressing it.
So can you tell us without looking into the file, just briefly what happened?
My lord granted stay as usual in the first appeal
Yes.
of the execution. Suit for eviction of a licensee that was decreed in trial court. They preferred an appeal and lordship as usual granted stay subject to conditions. So far the condition number 4 is concerned, your lordship has said that you are permitted to proceed with the Mintrovi proceeding.
But the last
Permitted to proceed with?
in profit proceeding
Yes,
granted under order 20.
yes, yes.
There the last line has created confusion. Court said I cannot perhaps proceed with the matter. That's the only thing.
What is there in the last line?
Yes, my lord, kindly come to that. Your lordship's order. Internal page 8, my lord.
8.
8. Clause number 4. It started, my lord, as you understand correctly, the respondents are permitted to move an application. My last line. In the event the appeal being dismissed, the court said, then I can't proceed with this. Judgment on this, my lords, order 20, rule 12, that may remain suspended after passing until disposal of that. But the court said whether I cannot proceed with that or not, that there is a question. So naturally, trial court did not proceed with the matter further and granted us liberty to move your lordships and get a clarification.
Just let us read the entire directions.
Last line, my lord, is creating the problem. My lord, restrain us from executing the order, if any. But so far proceeding is concerned, it may continue. Why should I waste my time? There, it has been started before the decree was challenged. Your lordship may pass an order restraining us from, whatever may be the result, that will remain suspended. It will not be executed. They are not suffering there, right? Proceeding may continue.
May I? Simple construction of English. Lordship will kindly first read the last line. In the event of the appeal being dismissed, if you put it right at the top with a comma, and then Lordship will read the rest of the part, the respondents are permitted. So the intention of the court, what I understand from the order was, my lord,
That
that
they will move only after the appeal is dismissed.
yes.
Well,
Precisely, my
kindly
lord.
see the order of the trial court.
Precisely, my lord.
At page 12, my lord.
Lordship, it's simple construction, my
But
lord.
whatever they are saying, even if it is to that extent, there you cannot have any grievance.
I'm sorry, my lord.
Even if the trial court is permitted to proceed and the process is inconsequential till such time the appeal is disposed of, how can you be aggrieved by that?
I perhaps not, my lord, but so far this aspect is concerned.
Because it will have no consequence. They just say that in the meantime.
Understandable, my lord. Understandable, my lord. Two things Lordship will kindly keep in mind. Lordship, on the when your Lordships were pleased to, my lord, stay the operation of the impugned judgment and order, my lord, the respondents took the responsibility of preparing the paper book because they said that we would delay the matter, and no paper book till date, my lord, has been served upon us, my lord. Lordship will kindly see the date of the order. Kindly see, my lord.
Why you have not taken steps for that?
They have not. They have not. Nothing has been served upon us because a specific submission was made.
Yes, we remember.
So, my lord, now Lordship will see who is really putting the cart before the horse.
But it is not that by non-preparation the matter has been delayed in any way. But then why did you not do it?
My lord, we have taken all the steps, my lord. We have already instructed the department to make it
LCR,
ready.
they have not even got the LCR. So it is.
Record will come, my lord. You can be blamed for that. Right?
It's not LCR anymore.
Oh.
It is a TCR.
TCR, my lord. Old habits die hard, my lord. What can I say? Only thing, my lord, Lordship will kindly keep it tomorrow, my lord, so far as I will take a small instruction with regard to this, my lord. But because my understanding, if I understood, my lord, the intention of the bench, my lord, correctly is that this is.
See, whether you look at it this way or you look at it that way.
Yes, absolutely.
The order, insofar as it affects you, will not be any different.
Precisely, my lord.
The consequence ultimately will be nothing. They are saying that in the meantime, we'll proceed some further. and then everything will be ready for whatever happens after the appeal. That is what they
Fair enough, my lord. I will just come back tomorrow with instructions, my lord.
can. In the meantime, we'd like to know what has happened about the trial court records.
Well,
I do not know, my lord. They would be.
I will do that, my lord. I'll check it out.
Please update that also. We'll
Let's
keep.
see the trial court's observation, my lord, at page 12.
Not required. We have understood what you're saying. Even if the trial court doesn't say anything, that's not the issue. So can you find out tomorrow what has happened about the trial court records being submitted?
By tomorrow may not be possible, my lord.
Therefore, we are asking you. Let's keep it on Monday. In the meantime, you find out.
Obliged, my lord.
As jointly prayed, listed under the same heading on let it be on 18th. 17th, we have fixed too many matters. 18th.
18, but
Yes, yes, I am absolutely fine. Obliged, my lord.
let's not.
Item number 12.
Yes. You have got the application.
My lord, I am for the respondent number 227, my lord.
On the previous day, my lord, reason of your lordship having been below to come to the conclusion to one criterion, that is, my lord, he rendered 340 days work, 240 days work, my lord, in a span of.
My lord, let me tell you, lordship, this is a checker. Yes, I've seen the last order. My lord, initially, my lord, two writ applications were there. First writ application was 10968 of 2003. Well, there, my lord, it was directed that we have to consider the case and say and pass a reasoned order. So that reasoned order was passed denying their claim. That was, my lord, by way dated 39/2003. Sorry, 22/1/2004. Thereafter, they preferred the second writ application, challenging that reasoned order dated 22/1/2004. And ultimately, that was transferred to the learned tribunal below because it was a matter to be referred there, my lord. It was referred in 2011 as a transferred application. That transferred application was disposed of, my lord, by order dated 2nd of March 2016. And their claim was rejected on the ground that there was a scheme of regularization and temporary status and regularization which was adopted by the DOT as well as BSNL. I am for the BSNL in this matter, my lord. So there, my lord, what has happened? The scheme says that 1/8/1998, one has to be there prior to that, one has to be engaged prior to that, and he has to be there on 1/8/1998. He has to work for 1 year, having 240 days. Then only he gets a temporary status.
the date the scheme has come into existence, he was required to be in office.
Absolutely. So that was not there. That was not there from 92 to 96.
Same issue we have decided in one case.
So, my lord, they were not fulfilling the conditions, so we did not grant them. Against that, they preferred a review application.
There were two writ petitions.
Sorry, my lord,
How many writ petitions?
One writ petition.
There was another one like this.
Two in number.
Two.
Yeah, দুটো writ
At
petition.
first in the year 2003, one writ
No, no,
petition
no, no,
was
no.
filed.
এখন তো you are come against a review application.
Only, no review application,
My lord,
but writ
that's why I
challenging the original order passed by the tribunal.
original order was in the transfer application, which is in 2016. That is, my lord.
No, we have considered this scheme in one case. We have
Oh.
passed the order, therefore we are. Yes. Perhaps on Thursday or Friday we have considered the same scheme.
Friday, the matter was taken up. I was not there. I was not well.
No, Friday, another matter of this nature was also taken up.
On his absence ground, adjournment was granted.
A learned friend is appearing for the Department of Telecom. I am appearing for the BSNL. So both have the same contentions, my lord, that they are not fulfilling the terms of the.
We have got it, sir. We have seen that scheme. We in prima facie, we were of the view that 240 days does not mean in a calendar year. It means 12 months, which is explicit from the scheme itself. But then argument was advanced that the scheme also contemplates that as on date of the scheme, he must still be in work. So that was the aspect which was argued. The Thursday or Friday, you were not appearing in that.
That matter.
In that case, there were 253 days. Here it is 286 days. So he has appeared in that case. You were appearing for the petition.
For the petitioner.
In that case,
no, my lord. There I was not the petitioner for the petitioner.
No, just if we remember correctly, then we want to avoid any inconsistency. Therefore, we are asking.
Is that matter made CAV, your lordships?
No, I think we
Then
passed your.
tag this matter also along with that. So, Millard, in order to, it will be convenient, Millard, and then also there will be no.
Where is the scheme at which page?
89. Original scheme formulated in the year
11089 scheme.
A scheme of 89, my lord, that was reintroduced in the year 1998. Kindly find at page 39, my lord, that on the very previous day, it was pleasure of your lordship, my lord, to go through that very page, my lord, page 39, my lord. That was the original scheme. Purport. Page 39 on the previous day, your lordships.
No, somewhere it said that those who have been
Page
left out,
39.
something like that. It was.
Page 39, my lord,
So as
that
a
gives
special
out
case, my
everything.
lord,
Yes, somewhere it said that those who have been left out, they are for their consideration that this scheme has been. Just
I am
let
not
us, just
concerned
let us
with
see.
the
Just
left
we'll,
out,
we'll
my lord.
see, we'll see.
The cause of action arose in the year 98. And thereafter, my lord, doors were opened, my lord, for the left out cases on two occasions, my lord. Firstly in the year 2001 and thereafter 2003, my lord. On two occasions, my lord, doors were opened for the left out cases. Left out does not mean that dropped out. Left out.
the lordship will
I am
kindly
not
come
to be
page
considered left out
57,
as
my lord.
because in the year 98 I was very much within the zone of consideration, my lord. So the cause of action arose, my lord, in the year 98.
Page 57.
1998, my lord. For that reason, my lord, the case has to be just, my lord, standing at
They
the
are
footing,
asking
my
you
lord,
to
in
show the scheme. You are not showing the scheme. You are making
scheme, my
submissions.
lord, on the very previous day, my lord, 39, my lord. Relevant page 39 scheme.
The special
Relevant
was
page.
considered at page 57, my lord. If the
4 or
lordship
5
comes.
pages are there, my lord, relevant 39.
Where does the scheme start? Why don't you show us where is the scheme?
Again, got a start, my lord, with effect from the first.
No, it is not. Page 39 is page 2 of the scheme.
This is what he has annexed.
The benefit you are claiming is under which scheme?
I am
11089 or 7989?
the
What is
scheme,
it?
my lord, the 39, page 39 is the original scheme, my lord, that was introduced in the year 1998, my lord. So, my lord, I am going to the relevant pages of the scheme, my lord. Kindly come to page 39, my lord. On the very previous day, my lord, it was lordship's pleasure to go through it, my lord. Kindly find that, my lord. I am reading it, my lord. Very relevant it is, my lord. This is the rule. That is a temporary status. As for the details given below, temporary status would be conferred on all the casual laborers
What is the date
currently
of
employed.
What is the date of this scheme?
name of the scheme at first page of that very circular, my lord, kindly.
Date of the scheme, date of the scheme. What is the date of the scheme?
The 7th of November 1989.
Let him tell us. Just wait.
7th November, page 36.
Therefore, we are saying
With effect from 1/10/1989, Lord.
1/10/89. So that is why that
Because
date
my lord will
was.
kindly see the scheme, what my learned friend is before 39, page number 39, my lord, there's a typed copy. Also will kindly see the second clause. The scheme will come into force with effect from
1/10/89. Yes.
Asking for the date.
So the paragraph 3, you must be relying on paragraph 3. It is applicable to the casual laborers employed by the Department of Telecommunication. This is your case. You are for the Union of India.
And they are from Department of Telecom, my lord, I have very less to say because, my lord, by our scheme in 1999, 2000, everything was transferred to BSNL, locks, bags and barrels. All the assets, liabilities, everything. So now, my lord, whatever
But this period is of 1992. That's the only problem. It starts from 1992 when he is asking that.
So at that time, you were not in existence. But both of you must have the same case.
We are having the same stand. And relief has been prayed against both of us.
So were you employed by the Department of Telecommunication on 1/10/1989? You were working on 1/10/89.
Oh, my lord. I joined that very service, my lord, of a casual labor of that lot, my lord, in the year 1992. And the scheme was reintroduced with effect from the 12th of September 1999, my lord. That was given, my lord. 1999.
Where is that scheme?
That scheme, my lord, kindly find that casual labor to be given temporary status as on 1st of August 1998.
Your lordship will
That was the cut out date, my lord decided. My lord, kindly find at page 50. My lord, kindly find at page 50. On the basis of this, my lord, circular, my lord, 225 candidates, my lord, who were engaged, my lord, long after us, my lord, in the year 1997, were given the temporary status, my lord, and we were, my lord, we were made to suffer the prejudice of superstition, discrimination, my lord. Kindly find that page, my lord, P650, page 50.
You are claiming benefit of which scheme? Which is the scheme you are
Scheme
claiming?
is the first annex, my lord. I have, my lord, on the basis.
But that scheme was of 89.
89 scheme, my lord, reintroduced in the year 1989.
By which communication? By which communication?
By this page 50.
Page 50.
Page 50.
Just let us read. Don't make submission. Let us read.
Yes, madam.
This is not regularization. This is for temporary status. For
Yes,
conferring, for conferment.
We are begging for that. We are for that. And so many people, my lord, they have, my lord, given the very, my lord, status, my lord.
Conferment
Again,
of
my lord.
temporary status.
My lord, a few lines.
So is there any stipulation as to the conferring temporary status? What is the requisites?
Requisite is, my lord, kindly find at page 44, P3.
No,
that circular was issued on 26th of August 98. 26th of August 98.
Page?
Page 44.
So before the tribunal, you were claiming.
Reintroduction of that very scheme, my lord, with effect from, my lord, 26th of August 98, by this official memo, my lord.
Before the tribunal, you are claiming temporary status or regularization?
Temporary status equal to others, my lord, who bypassed us. Huh? My lord, I have a few lines, my lord, before writing, my lord. I am referring to, my lord, 26, my lord. My lord, in connection with furnishing, page 44, my lord, in connection with furnishing a report on the subject mentioned above, has
Alright,
asked for
we'll come
by the
back.
direct Item number one. Item number one. Item number one. Item number one. One that has been fixed on 17, that I am praying lordships at 2 p.m. on 17 on 2 p.m. That I am only praying there. Page 44. The introduction, my lord, of the scheme, was made by the first circular dated 26th of August 98. And my lord, page 44, my lord. I am reading it, my lord. I am reading it. Casual labor, the title of the circular, my lord, casual labor without temporary status working in the department. In connection with the furnishing a report on the subject mentioned above, as asked for by the directorate, the information on the following subjects are urgently required. Directorate means, the Directorate of Telecommunications, that is the dot in short. Period of requirement, they are requiring the information from various offices to the effect that number of casual laborers without temporary status as on 1st August 98. That date is, my lord, taken as the cutout date, my lord. Thereafter, serial number 2, number of casual laborers without temporary status who have completed 240 days in any preceding year and in service as on 1st August 1998. This is another criterion to be fulfilled, my lord, by my client, my lord. That is, on 1st August 1998, he was very much in service of the dot. Third, my lord, requirement, number of casual laborers without temporary status working on jobs of regular nature as on 1st August 1998. Fourth, serial number of the casual laborers without temporary status working on jobs of casual seasonal nature.
In your OA,
At the bottom of the
in your OA, where is the prayer for temporary status? Show us.
wait allowed it. ওটা কি জজ সাহেবের কপি? কি বলছো? এইটাই। My lord, on the previous day, my lord required me, to file the exclusive application in the OA, my lord. That is OA. Actually, it is titled as, my lord, not OA, but transfer application TA1 of 2011, my lord. As
Has been
because
transferred from the High Court.
Yes, my lord. From High Court, it was, my lord, transferred.
So
my lord,
what was the prayer in the writ petition? Yes, the tribunal's opening paragraph says temporary status stroke regularization.
For granting temporary status, my lord, regularization is also to be made, my lord. That regularization, my lord, that is also, my lord, find at, my lord, regularization. Left out cases, my lord, kindly find at regularization page casual laborers 29. Main supplementary নয় ও জজ সাহেব যাচ্ছেন ওয়েতে আমি কি চেয়েছিলাম অ্যাকচুয়ালি ওয়ে এই ওয়েটা আপনারা কিপ ইট আর একটা কপি দাও মাই লর্ড জজ সাহেবের কপি দাও In fact, my lord, my first submission is, my lord, BSNL, my lord, cannot interfere with our case, my lord, as because the cause of action arose as far back as in the year 1998 or 98. Then, my lord, the BSNL was not nowhere in the picture.
BSNL has inherited all the rights and liabilities.
No, they will also
Therefore,
take up- take up
now
the
you
burden.
cannot say that BSNL will not. They have taken over all the rights and liabilities have now vested in the BSNL.
But my lord, actually, my lord, on the very
Where is
in
the
the
prayer?
year
Which page?
1998, the cause of action arose.
Where is the prayer?
Prayer. Supplementary, no, she way. Particularly the respondent 4, his main administrator, subordinate administrator, one of them, to regularize the petitioner's service in regulatory establishment in terms of the scheme called casual laborers, grant of temporary status and regularization scheme of the Department of Telecommunications in the year 1989 from the date of his juniors in the status of casual laborer have been brought into regular service and are given temporary status. First, prayer, my lord, and or give temporary status in the regular establishment with all consequential benefits and or to act in accordance with law.
Page 20 of this.
Page 20 there of my lord. Top paragraph. Top paragraph. Page 20. এটা নয় বাবু ওইটা এই আজকে কপি আজকের কপি একটু দাও ওই আমারটা দিয়ে দাও না এ বাবা এইটা কি করছে এই পেজ 20 আমার এটা supplementary
Here appears to be no. There appears
supplementary was given in order to prove that before 1st August 1998 I had been in service, as well as after 1st August 1998 I had been in service. So during that very interregnum period I had very much in service, unless until they are proving that I had been dropped from my service. That is the connotation as per the section 4 of the Evidence Act, as well as section 103 of the Evidence Act, my lord. They are duty bound to prove that I had been dropped out of my service ever during that very interregnum period since 1992 to 1st August 1998. If they show such an evidence, my lord, I shall be thrown out of the court.
Sir, মোট 3টে supplementary.
ওটা ছিল ট্রাইব্যুনালে ছিল
so regularization under which scheme? The page 44. Page 44 is temporary status. So for regularization, which scheme you are relying upon?
under the original scheme of 89, my lord, first annexure of my petition, instant petition, my lord, 30, of which relevant page is 39. So many pages are there.
89. You are relying on the 89 scheme.
89 scheme. As my lord is evident out of their, my lord, the affirmation made in that
89 scheme will not apply. His employment starts from 92. Yes.
My lord, I am, my lord, just, my lord, submitted, my lord, the
your 89. How can you rely on 89 scheme? You come to page 54.
I am not, my lord. Yes, my lord. Lay it aside. I am not concerned with the scheme of 1989, my lord. Still, my lord, I am very much eligible to claim a status of the temporary status, my lord, with effect on the 1st August 1998 on the basis of the, my lord, the scheme again introduced with effect from the 1998 scheme, page 44.
Page 44, yes.
Page 40, I have gone through. one by one.
Yes, there appears to be no consideration about the prayer for temporary status by the tribunal.
If your lordship sees, my lord, the reply.
No, we are not asking you to show the reply. Has the tribunal considered his prayer for temporary status?
The temporary status was considered. It was
Where? Show us from the order of the tribunal. Apart from making a note that he is also claiming temporary status, this fact has been noted by the tribunal in the first paragraph. Thereafter, there is no consideration.
lordship will kindly come to the first order dated 2/3/2016.
No, we are not going to look at 16.
No,
Oh, yes, the
order
tribunal.
says, my
Yes, the tribunal's order.
tribunal's order.
Yes.
Here, my lord, it is stated, Department of Telecom has issued a scheme circular dated 12/2/1999 for grant of temporary status to casual laborers who were currently employed as on 1/8/1998.
Yes.
So as on 1/8/1998, he was not there.
No, how do you say that?
We have the records. We have produced the records before the
You
tribunal.
see page 54.
54.
54. That is your document.
There is no page.
Annexure P10. We don't know, sir. That is how you file it. We are ourselves finding it difficult, but somehow we manage. 98, 99, your statement very clearly says he was there. This is not in dispute. This statement is not in dispute.
But we have calculated as per calendar year, my lord. In a calendar year,
That's a different thing. You said he was not there. You said he was not there. Therefore, we are showing you. Now you are saying something different.
One.
Please, this is not the way. Please sit down. We'll call you. Just wait.
Well, 92, 93, they have clubbed together and then they have got 286 days.
We are on 99.
99.
Yes, you said he was not there. He is very much there in 98, 99 both.
1996 December, he has worked. After that, my lord, he was disengaged. He
That
was
is not
working under
relevant.
he was working under a contractor. He was under contractual service.
From?
1997 January. So he was not in the regular establishment as a casual.
From 97 January.
97 January.
This is your stand before the tribunal.
Our stand before the tribunal.
Can you show us where you have said this?
We have stated in the reply, my lord. We have stated in the reply, which is that page. My lord, if your lordship kindly finds the reply, my lord, there's no pagination here, what he has supplied.
What is the internal page of the reply?
My lord, at page, the second page, my lord. Second page, my lord. Your lordship got it?
Disengaged in January 97.
So as of 1/8/1998, he was not there in the establishment. So he doesn't come under the scheme.
My lord, I invite them to.
By us, and that was also.
But your statement at page 54 shows that he is there in 97, 98, 99. This is issued by your office. Accounts officer. Calcutta telephones.
That time, my lord, we have produced the records also. Whatever records were there, we have produced the records.
No, this is statement. You have not denied that this statement. In fact, it is certified also, certified that the engagement particulars of the above full-time casual laborers have been verified from the office records and found correct. checked and found correct. The divisional officer has signed, group officer has signed. It is signed by the chief accounts officer. This statement means nothing.
So whisper about in my reply also or in the order. So this was not produced at the relevant point of time, I think. So it was produced during the review application, but it was not taken up. The original application was taken up, the transfer application, it was not there.
This statement was not there.
Not, it came up only in the review application.
How do you say that?
Because my lord, no whisper of that, neither in my reply nor in the order. But it is in the review application, review order also.
My lord, 1 minute, my lord, I shall take.
It comes to the review order, my lord, is second page, last paragraph.
What is the date of this document at page 54?
'99, it has been attested. 1999, it has been attested.
This is an order of 28/5/99, attested on 10/11/99. And 28/5/99 was an annexure P2 in the OA. By inference, don't deny a fact. Please be sure that it is not there, then you deny it. Because I have not replied, because it is not in the order, therefore it is not there. How can you say?
Supplementary evidence.
We would rather rely on what you submit than to search the documents to verify every fact that you submit. That's not the way to counter a fact. So for everything you say, if we have to search the entire file, then it will become impossible to decide any case.
That case, my lord, a report may be called for.
What record? It is right there. It is an annexure P2. That was his claim, not considered. Just because you didn't reply, therefore it was not there. That means you don't deny it is an admitted position. The document is admitted. You have chosen not to deny it. Still, the tribunal has not considered. Why? In the review also, it has not been considered. At least his claim for temporary status should have been considered. Whether he gets it or not, we don't.
This document is concerned, my lord. It is not at all legible, my lord.
Oh, it is.
I cannot read it, my lord.
It is very much legible.
Your lordship will kindly see, my lord.
Yes,
Kindly see.
it's very much legible.
No, in that case, we shall call for a report from that department, my lord.
What
Let them
report?
come and say. Let them come
What
and say
report? You have dealt
it is
with
a
it in.
genuine, my lord.
You
let
have
them come.
dealt with it in the review. You have dealt with it in the review. What report is to be called for?
Review was, my lord, we did not say anything. Review was in the court.
The review was?
The court decides the review application is not heard out, my lord.
The review was not heard in court.
Generally taken up, and then it is heard out that the final judgment is passed.
So we are to presume that there was no hearing.
One day it is
So
taken up.
what are you trying to say? We don't know. The judgment records your name, counsel appearing, the judgment record, heard counsel for both the sides, and you are saying that it was without hearing. Just submit anything, sir. This is
The tribunal, it is sent for admission.
We don't know. We can't take off notice of such submissions. Can't submit just anything to defeat a claim.
Whatever was placed before us, my lord, we have submitted in our reply.
You have not
Now,
considered.
if some document is there which has not been dealt with, my lord, let the department come and say.
No, sorry. Let us see the review order first then.
My lord, kindly find 81 page. He is submitting contrary to the report of the office. Page 81, only one page, my lord. Page 81 and 104, 104.
See. Draft 11 and 12. Yes. Paragraph 3 of the certified. Is not the result. 11 11/4/20. Yeah. Well, except people.
Documents could have been verified also.
Yes, people.
My lord, one thing, my lord,
Entire brief is falling apart. Yes.
my lord, let me read, my lord, only one page.
We'll allow, just wait, don't be impatient. Statements. Page 54. See page- This is good. This is an exception. You will get it from the supplementary affidavit filed today. Six. Think about P2 in your reply. Because just now you told us that you have not replied. In your reply, you have not said anything about P2. Therefore, we are asking you just check.
My lord,
Please wait, sir. Please have some patience. Please wait. You can't force us to listen to you. We have asked you to wait.
তুমি একটা বার করে আমার কাছে দিলে আমার সুবিধা হয়, এটা P1 না হওয়া। সাপ্লিমেন্টারি অ্যাফিডেভিটটা বার করে রাখো। ওখানে আছে। এই যে, এই যে।
Also, this has been considered. Page 2 of the P2 has been considered in the original application also.
We have given a general denial there. What I see, what I find from here.
It is required to be considered. Yes, what at page 81 you are trying?
Yes, my lord. Page 81, my lord. This is, my lord, a report of investigation made by some deputy manager, my lord. Kindly find and page 81, my lord. I am reading it, my lord. It is
No,
very
no.
much vital.
This is a file noting. We are not going to consider the file noting.
My lord, one thing, my lord, kindly see,
Sorry.
my lord. This was made, my lord.
No file
Oh,
noting.
my lord, kindly find that, my lord.
We will not consider. We will not consider a file noting. You must be knowing the law. These file notings cannot be relied upon to assess the rights of the parties unless it culminates into a decision.
If they deny,
Noting in the file means nothing.
they have not denied it, my lord.
Noting in the file means nothing.
Acha, or
Law is very well
at
set.
first, my lord, as under the direction of this Honorable High Court, my lord, what regent order was passed by the kindly find at page 84. That very official is saying that in the year 1989, I had not been in service. Again, my lord, one page another. My lord,
you were appearing in the other case also. Who was appearing for BSNL in that case? We don't want any inconsistency. Therefore,
my lord,
it's clear he has not been considered. His temporary status application has not been considered. It has to be considered. And this is not denied by you. This work statement is not denied by you. You have said in your reply that 97, after 96, he was disengaged and then in 98. But this is not denied. This is certified. So his submission is supported by a document and your submission is just a statement in the reply. So therefore, how the tribunal has proceeded is unique. The tribunals just see what it says. Just see, come to the order. Therefore, the applicant has not been able to contradict the respondent's stand that beyond 97 he was only engaged as a job contract. What a consideration by the tribunal. He makes an assertion backed by a document issued by you, and then the tribunal says he has not been able to controvert your reply. Unique. But we don't remember what we decided in the other case. That is why we are holding back. Who is appearing? Is anybody else appearing for BSNL apart from you?
Yes, three other counsels are there, my lord. I'll get.
Can you help the court? Can you find out whether it was on Thursday or Friday?
Certainly.
The same issue we have considered in another case.
I will.
A right arising from the same scheme of 1898.
If your lordship kindly keeps this after 1 week, my lord. In the meantime, I'll find out the advocate
We'll
as
keep
well
it
as
on. We'll keep
so
it
far
on.
as this document is also concerned, whether this is a genuine
No,
one.
no, nothing. Now we are not going to allow any opportunity for filing any affidavit.
This entire
No, sir. Sorry.
entire system of
No.
regularization of
You
casual.
have had your entire opportunity. You have availed the opportunity. You have not assailed the order of the tribunal. Therefore, we are not going to allow you to file anything.
Process has stopped long time back.
We don't know. We don't know.
And these people have, I think
We
they have
also
all
don't know
lost
what
the
we are going to
challenges.
do, but these submissions are not going to help you.
No,
We are only seeing the tribunal's order as it is.
It's a 33 years back, my lord, case.
don't know,
So
we
he
don't
has
know.
retired in the meantime.
We don't know.
His retirement age is there.
We don't know.
compensation.
Can he
We don't know.
retirement age chole
He has crossed the age of superannuation.
Yes.
How do you know?
In 92, he was working as a casual, 33 years, 34 years.
But the tribunal has not considered anything. How can he be made to suffer this injustice? Something has to be done for him. Just see the reasoning given by the tribunal.
But at this stage, my lord, that would be
Trust-
opening a floodgate. If something happens like this, then entire persons who were there all will come.
We don't
BSNL is in
know.
the process of revival, my lord.
We don't know whether we'll
50%,
be.
50%,
What
my
we'll do,
lord,
we
they have
don't know.
taken
Just
voluntary
find out.
retirement.
My lord, one thing, my lord, one thing,
Is
my lord.
another matter. An order. You inform us.
Well, can the number be given by the Lordship's court
We-
officer?
If we knew, we would have. We are trying to find out ourselves. But you please also help us.
Yes,
We have asked him.
It was taken on Thursday. my lord. Thursday.
Very difficult for us to say, but we think maybe Thursday or Friday.
I'll try.
Only one page, 104, my lord. That
Monday,
is
Monday. You
the issue.
yes.
BSNL administration.
And section 304 of the CRPC will be applied in this case.
The BSNL will not remain there, my lord. Now situation is like that.
115 also.
এটা আপনার আছে।
Repeatedly they are lying before the court. Okay.
6 matters that
Step number 15.
On last occasion, my lord, I was referring to a judgment delivered by the Honorable Supreme Court, reported in AR 1985 Supreme Court 1196. Srimati Punamal, etc., petitioner versus Union of India. Prior to coming to the judgment, my lord, I once again draw your lordship's attention to page 43, paragraph 18 of the tribunal judgment. The third prayer of the petitioner relates to grant of revised pension to the petitioner after restoration of the commuted amount of pension. We find that the Finance Department, Government of West Bengal has issued order under memo number 01F pen dated 4th January 2010 regarding consolidation of the restored portion of pro rata pension consequent upon revision of pensions on the recommendation of the Pay Commission. The formula for consolidation of the restored restored portion of pension is different from the order relating to revision oblique consolidation of pension for the other state government employees. Under memo number such and such dated 25th February 2009, the pension of existing pre-2006 pensioners is to be consolidated with effect from 1st October 2006 by adding together the existing pension, dearness pension where applicable at the rate of 50% of the basic pension and notional basis, dearness relief at the rate of 24% of basic pension plus dearness pension at the rate of 50% of the basic pension when applicable on notional basis, and made of weightage of 40% of the existing pension, provided that if the total amount so arrived is less than 3,300, the same shall be stepped up to 3,300. At that material point of time, my lord, the minimum pension payable to a state government pensioner was 3,300. So it was directed to step up to that minimum pension when it will not arrive. Then, my lord, may kindly come to page 44, last para. We note that in this case, the date of effect is 1/1/2010, which is different from that in the case of normal state government pensioners. No fitment weightage has been given, and moreover, there is no stipulation of a provision corresponding to para 4.4 of the Finance Department's memo regarding consolidation of pension in case of normal pensioners. The central government adopted different formula for revision of restored amount of pension in case of absorbee pensioners. We agree with the submission of the learned advocate for the state respondents that since the service condition of the state government employees, oblique pensioners are to be governed by the law or rules to be made by the state government under Article 309 of the Constitution of India, there is no legal requirement that whatever is applicable to central government employees or pensioner is to be made applicable to the state government employees pensioners. But the ratio of the decision of the Supreme Court in the case cited herein before is that there should be no distinction between the absorbee pensioner and normal pensioner. I emphasize on this observation, my lord, that there should not be any distinction or difference between two groups of pensioners. That the absorbee pensioner should be treated in all respect at par with the normal pensioners. We hold that this runs contrary to the principle laid down by the Honorable Supreme Court. We hold that the same principle of revision or consolidation should be followed by both those categories of pensioners. I raise my submission in this regard, my lord. Now, my lord may come back to the decision of the Honorable Supreme Court. And the relevant paragraphs, my lord, para 1, 3, 4, and 7. Should I start with para 1, my lord? I have already given the copy of the judgment.
85 Supreme Court judgment.
My lord?
85 Supreme Court judgment. What are you referring to? 85 Supreme Court judgment?
85 Supreme Court.
Yes.
1196.
Yes.
Components reference to 1985 3 SSC, page 345.
345.
3, 4, 5.
Yes.
So, my lord, paragraph 1. Promise of socio-economic justice depicted in rosy language of Articles 38, 39, and 41 is being translated into a real action-oriented program by the stand taken by the Union of India and the Ministry of Finance in this group of petitions and applications for special leave which deserves approbation and commendation. Amongst the neglected section of the society, women form a bulk. In that bigger class, widows are possibly the worst sufferers, both socially and economically. To them, a helping hand is extended for providing succor solely needed by the two statements made in court by Mr. Vidatta, learned counsel appearing for the Union of India and the Ministry of Finance. Throughout the course of hearing, Mr. Vidatta adopted a positive, constructive, and helpful attitude, and he is equally entitled to our appreciation. Then, my lords, paragraph 3. Family pension came to be conceptualized in the year 1950 when a government servant dies in harness or soon after retirement in the traditional Indian family. On the death of the only earning member, the widow or the minor children are not only rendered orphans but faced more often destitution and starvation. Traditionally speaking, the widow was hardly in a position to obtain gainful employment. She suffered the most inasmuch as she was deprived of the companionship of the husband and also became economically orphaned. As a measure of socio-economic justice, family pension scheme was devised to help the widows tie over the crisis until the minor children attain majority to extend them some succor. This appeared to be the underlying motivation in devising the family pension scheme. It was liberalized from time to time. The liberalization was, however, subject to the condition that the government servant had in this lifetime agreed that he shall make a contribution of an amount equal to 2 months of emoluments or rupees 5,000, whichever is less out of the death cum retirement gratuity. Those government servants who did not accept this condition were denied the benefit of the family pension scheme. Focusing on the liberalization that was introduced in 1964, it transpires that the widow and the minor children of those government servants who died prior to 1964 are not eligible for the benefit of the liberalized scheme. The other class which was left out by the liberalization scheme was those government servants who specifically opted out of the family pension scheme 1964. The resultant situation was that since January 1, 1964, there were in force two parallel schemes in operation, namely a pre-liberalized scheme which continued to be in force for those who retired prior to 1st January 1964 or those who did not contribute out of the death cum retirement gratuity, roughly styled as non-contributory scheme. The other was the contributory scheme. Both these schemes are incorporated in Rules 54 and 55, respectively, of the Civil Services Pension Rules 1972. So, my lord, there was a rule.
Paragraph 6.
Paragraph?
Read paragraph 6.
I am coming to that, my lord. Accordingly, since September 22nd, 1977, the contributory scheme ceased to exist. A very anomalous situation arose. The widows of the government servant who had not agreed to make the contribution in accordance with the 1964 scheme were denied the benefit of pension scheme, and this disability continued even after the changes introduced in 1997 when the scheme ceased to be in contributory. Such widows moved this court in writ petitions. Widows similarly situated had also filed writ petition number 3749/84 in the High Court of Judicature at Bombay. A division bench of the High Court rejected the writ petition for reasons which, in our opinion, are wholly untenable, but that is beside the point. We accordingly granted leave to the petitioners whose petitions were dismissed by the Bombay High Court. Rule 9 was issued in writ petitions filed in this court. then my lord may kindly come to paragraph 7. It is not necessary to examine the concept of pension, as already held by this court in numerous judgments that pension is a right, not a bounty or a gratuitous payment. The payment of pension does not depend upon the discretion of the government, but is governed by the relevant rules, and anyone entitled to the pension under the rules can claim it as a matter of right. Devkinandan Prasad, State of Bihar, 1971, etc. My lord. And D.S. Nakara of Union of India, year 1983, Supreme Court 130. Where the government servant renders service to compensate which a family pension scheme is devised, the widow and the dependent minors would equally be entitled to family pension as a matter of right. In fact, we look upon pension not merely as a statutory right, but as the fulfillment of constitutional promise, in as much as it partakes the character of a public assistance in cases of unemployment, old age, disablement, or similar other cases of undeserved want. Relevant rules merely make effective the constitutional mandate. That is how pension has been looked upon in D.S. Nakara's judgment. At the hearing of the group of matters, we pointed out
there is no judgment. It is not a binding precedent. It is a matter decided. Government of India has come forward and said that, look, for a small period, this objection was raised. We are not a decision.
No, my lord, the principle
Between 64 to 77, the contribution was not made. Those persons were being deprived. 77 liberalized, no contribution required. Court said, asked the Government of India. Government of India said, all right, for this period, we are not going to make. This is not a binding precedent. There is no decision here. This is a consent order.
No, my lord, it is order.
Yes.
In this judgment, the Honorable Supreme Court has explained and expounded the principles
That
of
you have
pension.
already read. That you have read. Yes. That
My
you
lord,
have-
this is the reason that I am referring to that judgment.
But that
In-
has
in
to,
fact,
everything has to be read in the conspectus in which the decision is rendered. There, the decision is rendered in a particular conspectus of facts. Whether it is here, the same situation arises. You have just now read paragraph 7, which says pension, what is the concept of pension, Devkinandan Prasad, all these judgments, as per rule.
As per rule, my lord.
Yes.
Yes.
As per rule.
Devkinandan Prasad and my lord D.S. Nakara case.
As
DS
per rule.
Nakara, as per
So if the rule provides, he will get. That is what it says.
my lord.
Yes.
Grateful to the Lord. And from this discussion, my lord, I would like to submit that if there is no intelligible differential between two groups of pensioners, that is the absorbee pensioners and the normal pensioners, then why the widows of the absorbee pensioners would be deprived of the family pension?
That you have submitted.
I am putting this question to myself. And according to my humble understanding, my lord, that it creates a discrimination, a hostile discrimination between two groups of widows. As it has been pointed out, my lord, by the Honorable Supreme Court, that the widows are the most sufferers in our society. After the death of the husband, there is none to look after them. In modern society, the sons and daughters are living apart. Even living
You are reading a judgment delivered in 85. You are aware that much later, the whole concept of pension was finished.
But nowadays, my lord, the
So
situation
therefore,
has turned worse.
whatever you are reading has to be, therefore we are saying as per rule. Ultimate thing is, what is the rule?
But rule has been stipulated in D.S. Nakara case, in Devkinandan Poddar case.
Yes.
And in this judgment, my lord, in fact, the central government acceded to the issue.
So therefore, this judgment is not a binding precedent. This is a
No, this is not
consent order.
binding precedent.
This is a
I
consent
have
order.
referred the judgment only to elucidate, my lord, the concept of the family pension.
That you have read. That you have read.
So, my lord, it is the constitutional obligation of any government to fulfill the obligation under Article 39, that is directive principles.
Therefore, we are saying that pension was done away with altogether. and it stayed like that for quite a long time. It is not that it is not within the government's power to stop a pension scheme.
So, my lord,
38, 39, 41 has been referred to, that we have seen, but that is in the context of the rule as existing. Therefore, Devkinandan Prasad and Nakara case has been discussed.
Nakara case, yes.
So ultimately, the rule will prevail. Here, the rule is that absorbees will not get. This is the rule here.
So, my lord, any rules
Yes.
which is not in conformity of the constitutional mandate,
All right. So that is the main thing. That is the main thing.
which is not in conformity with the constitutional mandate, has to be declared ultra vires.
Correct. Correct. That there is no dispute about this proposition.
My lord.
Nobody can dispute this
No,
proposition
my-
across the courts throughout the country.
Obliged, my lord.
Yes.
So,
But that has to be established.
the sub-rule 7
Yes.
of Rule 189A
Yes.
was introduced
So
just,
let's see the rule. It's all about whether the rule is discriminatory or not.
my lord.
If the rule offends 14, 16, you may
14,
have a
16
case.
and
If
21,
it
my
does not, you may not. So let us see the rule. That's all.
That's all.
Yes. Which rule?
বই আছে তো?
We have the rule. You are referring to DCRB.
DCRB rules.
We have it. Which provision you are referring?
189A sub-rule 7, my lord. Government would have no liability for family pension under Rule 15 of the said rules in respect of government servants absorbed in the undertaking referred in clause 4. 6.
189.
189A sub-rule 7, my lord. This rule is under challenge.
Sub-rule 7.
7.
And where is chapter 10? Page 35.
Chapter 10, Rule 15.
15 we have seen. In case of death of accounts. Yes. So you are saying that sub-rule 7 is ultra-virus.
Ultra-virus. Since it has made a hostile discrimination to group of employees, although it has been decided by this honorable court that there is no distinction between two group of employees and they are on the same footing. So why this distinction, my lord? And my lord, more so, when a provision takes away the right to life from a citizen, that provision in that respect also, my lord, from that corner of views, has to be declared ultra-virus to Constitution, since it offends the Article 21 of the Constitution.
What is the case number, that judgment that the judge just read? WP80.
Okay.
That was case
587093 of 81.
Yeah, 1985.
Yeah, 1985 Supreme Court.
No, not that one, sir. You were just now reading that the court has held that there cannot be two class of pensioners. That was the tribunal's order.
Judgment delivered by the
Tribunal.
which has been ratified by this honorable court.
Yes, where is this court's order?
Yes, ma'am.
Ratifying that judgment.
Page 51, 52.
High Court judgment, my lord, from page 52 onwards
Paper.
of the paper book. My lord, relevant portion of the judgment at page 58, last para. Dealing with all the judgment as relied upon by the parties and upon meticulous consideration of the same, and on the rudiments of the admitted fact that prior to medical examination, the respondents are treated as normal pensioners, and they were granted the revised benefits in terms of ROPA Rules 1986. The learned tribunal correctly observed that the commutation of pension and restoration of commuted portion should be on the basis of the pension which was admissible on the date of medical examination, and the state respondents were directed to grant such additional benefits, if any, upon verification of facts, and may be admissible according to the rules of commutation of pension. The learned tribunal further directed that the applicants should be allowed dearness relief on the full amount of basic pension to which they would have been notionally entitled. The learned tribunal further observed that the state respondents have made a distinction between the absorbee pensioners and the normal pensioners by framing different scheme for revision oblique consolidation of pension, and such action runs contrary to the principles laid down by the Honorable Supreme Court, and it was held that the same principle of revision of oblique consolidation should be followed for both the categories of pensioners, and it was directed that after restoration of the commuted portion of pro rata pension, it should be revised if in the meanwhile any revision of pension has been made in the case of normal state government pensioners, and that thereafter on each occasion of revision of pension for normal state government pensioners, consequential benefits should be extended to the absorbee pensioners by applying the same formula. The argument to the effect that there is no obligation on the part of the state government to adopt all the rules applicable to central government employees and central government pensioners has been rightly discounted by the learned tribunal on the basis of the dictum of the Honorable Supreme Court in the case of Welfare Association of Absorbed Central Government Employees in Public Enterprises Supra. In the case of State of Bihar and other Supra, as relied upon by Mr. Majumdar, the dispute was that Fitment Committee ignored the terms of reference as contained in the resolution of the state government and erroneously recommended the revised pay scale, and in the backdrop of the said facts, it was inter alia observed that the pay scale essentially depends upon the resources of the government, and that it is not always possible that the resources of the central government and the state government are the same or even for the matter between two states. In the case of State of West Bengal Supra, the controversy involved centered around the issue as to whether the senior laboratory assistant in public works road department are entitled to have the same pay scale at par with the research assistants, and as to whether the chief engineer of the directorate was competent to modify or amend RUPA rules. In none of the said judgment, the lease was pertaining to grant of pro rata pension and gratuity to government servants absorbed in public sector undertakings, and that as such the said judgment are distinguishable on facts. It is well settled that what can be, then my lord, this honorable court has relied on the principle that writ court can only amend the legal errors committed by the tribunal.
Yes.
My lord, this court has also observed the learned tribunal, upon dealing with all the factual issues, arrived at specific findings in consonance with the judgment of the Honorable Supreme Court, and we don't find any error, least to say any patent error of law, in the judgment impugned. As a model employer, the state government must conduct itself with high probity and candor and ensure that its employees do not succumb to procedural rigmarole, particularly when the claim pertains to pensionary benefits. The scope of judicial review is very narrow and limited, and such jurisdiction should be exercised sparingly and only in appropriate cases where the judicial constraints of the court dictates. So, my lord, the judgment delivered by the learned tribunal has been accepted by this honorable court and has got the approval. So that order and judgment, my lord.
And in the tribunal, before the tribunal also, one of the claims was for family pension.
Yes, my lord. But
that was rejected by the tribunal and affirmed by the High Court.
Only because of the reason
that there was a rule.
There is a rule. And
so therefore now you are challenging.
And I did not challenge the rule. So, my lord, it was the observation of the tribunal and the tribunal that unless the rule is challenged and declared ultra-virus to constitution.
No, it was as long as the rule is there, it cannot be.
There is no possibility for the tribunal to pass any order contrary to the rule, unless the rule is declared ultra-virus.
That the court has not said. Court has said as long as the rule is there, it cannot be granted.
So, my lord, in this particular case, the rule has been challenged, particularly that sub-rule.
Yes.
The sub-rule 7 of the Rule 189A,
yes,
which diverts the widows of the absorbee pensioners from getting the family pension.
Yes.
My lord, in this instant petition, the rule has been challenged.
Yes.
My lord, kindly come to page 15. The prayer before the tribunal. Provision contained in page 15 of the paper book. 15.
So we take it. It has been challenged. We take it. Where is the order of the tribunal? Now, what the tribunal has decided?
Tribunal has not decided anything.
Where is the order?
My lord, it was decided by this honorable court to hear the matter.
Oh, because the single
Because this is pending since 2000. This is a case of family pension.
All right.
And it is pending for long 10 years.
So then, if we have understood correctly, your submission is there cannot be two kind of pensioners.
My lord.
Since we are also pensioners, the benefit of family pension cannot be denied. A rule which contemplates this is ultra vires. It is not based on any intelligible differential. This is your submission.
My lord. My lord, my basic submission is, if there is no distinction between two groups of pensioners, there shall not be any difference or distinction in any matter relates to the service condition.
So there is no distinction between you and the state government pensioners.
My lord.
Factually, is there any distinction between you and the state government pensioners?
That distinction was made by the central government earlier by denying their liberalization pension scheme, division of pension, by denying to give them the dearness relief, etc. And for this reason, we moved before the honorable tribunal. And tribunal decided this fact, that there is no distinction between two groups of pensioners. So if there is no distinction between two groups of pensioners, there should not be any distinction.
Yes.
In pertaining to grant of family pension.
Yes. That's all.
That's all.
Yes.
Kindly take 2 dates.
— 26. Whose husband died? Petitioners. How many petitioners are there? So this is with date with respect to petition number 1.
12 November 2008.
9.
2008. 12 November 2008.
Yes.
In Malad, the question will be considered by the and the cause of action happens on by the order on travel. The kindly see the original application was filed. What is
15. 1057 of 2015.
cause of action? After 5 years,
How long after the order passed by this court in the earlier writ petition?
that was
1st August 2016. So before the writ was decided, this had already been filed. And the earlier order passed by the tribunal is dated
21st June 2013, my lord.
yes.
The rule. I will also go on page 40.
Page 40. Yes.
Application of this rule. Students have public will apply in case of death of a government servant who entered in service first in 1965, was in service first April 1965. That is 3-year service. Any benefits can also be admissible in case of a death of a death. Without observed was the of compensation invalid retiring superannuation pension or judging provided the completed 3-year service. Then Malad. Who were not applied to persons who retired on first April 1960, but may be employed on the date other thereafter the persons take from contingency, workshop staff. On that particular date of day, when his husband or husband was not in service. Because according to the question of his they were just
66.
6 November 1966. And mother called Food Corporation of India 1964.
So they were in service before 1st April 1965. Before 1965, they were in service.
6 November 1960.
No, I have missed. Please repeat what you said.
Their husband
Can you use the mic, please?
their husbands are employee of the state government.
Yes.
There's an agreement between the state government and the Food Corporation of India for absorption as a Food Corporation of India's employees.
Yes.
There's an agreement dated 26 November 1966.
Yes.
And Food Corporation of India Act came into force on December 1964.
Yes.
According to the Food Corporation of India Act 1964, they were the employees of the Food Corporation of India. And they have got all retirement benefits on attaining the age of superannuation from Food Corporation of India.
Yes.
Now, according to the Rule 189,
the husbands were getting pensions, pro rata pensions. There is no dispute about it. Now, my lord, whether the family pensions.
No, which provision of 101 you were relying upon?
First, 101. This rule shall subject to the provisions of the apply in case of a government servant while in service.
All right. So he was not in service.
He was not in service. But if he was in service, their husband was in service, then Malat at the time of retirement, then Malat certainly were obliged to pay family pensions. Now Malat, my learned friend is contending that the ordinary pensioner and Malat the so far as pro rata pensioner, why the state government has made two classifications. Can you see the language of Rule 189A, sub-rule 7?
Yes.
Grant a pro rata pension and gratuity to the government servant absorbed in public sector undertakings on or after 16 June 1967. Can you say that date? On or after 1st June 1967. But they were absorbed on 26th of November 1966. On permanent basis, on or after 16 June 1997 in the service or post under a corporation or a company fully substantially owned and controlled by the government or in a body controlled or financed by the government, hereafter referred to the permanent government, servants shall be eligible for pro rata pension and gratuity based on the length of qualifying service under the government till the date of absorption in accordance with the pension rules of the government in force on the date of absorption. The emoluments for the purpose of pro rata pension and gratuity shall mean emoluments which the government servant would have drawn under the Government of India but for its transfer to the undertaking. The amount of gratuity or pension or retiring gratuity should be currently worked out and will be communicated to the government servant as the undertaking as and when the government servant absorbed. Then Malat, Roman 4. Every government servant shall exercise an option within 6 months from the date of absorption or the date of coming into force of this rule, whichever is the latter. Receiving the gratuity or pension and retiring gratuity already worked out under the usual government arrangements. Receiving retiring gratuity and a lump sum amount in lieu of pension worked out, reference to the communication tables, obtaining the date from which the communicated value of the pension payable. Then kindly see Rule 7. Rule 6. For the period of service rendered in the undertaking, the absorbed government servant shall be entitled to all benefits admissible to other corresponding employees of the said undertaking. Government would have no liability for family pension under Rule 15 of the said rule in respect of the government servant absorbed in the undertaking referred to in clause 6. But at the time of entry into the Food Corporation of India, at the time of death of their husband, this was known that their husband had exercised their option. They should be absorbed in the Food Corporation of India. They would not be entitled to any get pensions, family pensions. Only get pro rata pension. Now, Malat, kindly see.
Yes.
Whether there is a differential between the pensioner, ordinary pensioner, and family pensioner of a absorbed employee of the Food Corporation of India can be made equal. I'm putting the question to myself. On the same footing, in a state government employee, when dies, his wife, legal heirs getting pensions on the basis of the rules framed under Article 309. But their right to get pension is not a fundamental right. But till the amendment of the Constitution in 44th Amendment, right to get pension was a fundamental right. That was decided by the Supreme Court. AIR, sorry, 1971 2 SCC, page 334, paragraph 15, 16, 28 to 33.
Sir,
1971 2 SCC, page 330, paragraph 15, 16, 28 to 33.
He's giving it. Three zero.
Paragraphs. Which paragraphs you are relying upon?
Just 1 second. Paragraph 15, 16.
' 15, 16.
And 28 to 33. Can you see paragraph 16? We are not inclined to consent of Mr. Jha that no fundamental rights of the petitioners are affected by passing the order dated 12 June 1968. We will in due course refer to the pension rules bearing the matter to certain decisions. In our opinion, the right to get pension is a property, and by withholding the same, the petitioner's fundamental rights guaranteed under Article 19F, 1F, and 31 are affected. Kindly see, when this 19(1)(f) and 13(1) has been omitted from the Constitution by 42nd Amendment. (19)(1)(f) and Article 31(1). Have you got it?
Yes.
Constitution, mother.
Yes.
19(1)(f) has been deleted by 44 Amendment from 20th June 1979. Most probably we will also recollect after recalling the emergency, the then Prime Minister placed this bill before the Parliament.
Yes. 20th June 1979.
Then from 21st June 1979, a right to get pension is not a fundamental right. Then there must be a violation of statutory right or fundamental right. A statute can be declared alter virus. 4 principles has to be applied. If there is no legislative competency, number 2, that is violative of any provisions of a fundamental right of the Constitution, or there is a violations of any constitutional provisions, or there is no conferment of power of the legislature. Pension Act is a central law, and on the Pension Act, this rule 71, but rule has been framed under 309 of the Constitution provision. That means we have got legislative power under the Constitution. Then there is no other provisions that we have violated. There is no such pleading. Then fundamental right to get pensions, Article 21 or 14. Can a person who is getting full pensions or ordinary pension, being husband, employee of the government, being employee of the husband, be equal to the person concerned whose husband has not worked on the last date of the working with the government? These persons cannot be equated. And in 1985 Supreme Court, the Supreme Court kindly considered the judgment of Nakara's case. The Nakara case has been distinguished by the Supreme Court in 1990, volume 4, SSC, page 207. Why? Doctrine of precedent has been considered and the ratio decision that. Judgment of Justice Shobosachi Mukherjee, Chief Justice, BC Rai, 1990, volume 4, SSC, page 207. Paragraph start paragraph to leg, paragraph to leg.
1990 volume 4 SCC.
1990 volume 4 SCC, page 207. Kishan Kumar versus Union of India. That was the reference. For that, what is the diction? Not diction. Paragraph. Paragraph 18, 20, 19, 33, 25, 30, and 32.
18, 19,
19, 20, 30, and 30 and 32. Adjustable. Adjustable. Kindly see paragraph 30 and 29 and 30 and 30. Nakara case has been diluted by this judgment, by the constitutional bench.
Paragraph 33 and 31 and 32. Perhaps you are relying.
If Nakara case has been diluted by this judgment.
Moral obligation.
Moral obligation. And what can there be a mandate upon the government to comply the moral obligation to pay pension who was not retired from the government service on the date of retirement? And these two type of pensioners, my land friend is a normal pensioners and pro rata pensioners. He has accepted it when he was observed and till continued. And 2010 retired, he has not taken a step. 2015, he has filed the original application before the tribunal. And my land friend has relied upon judgment of the Supreme Court, 1985, CSSC page 345. Srimati Poonamlal versus Union of India. that your lordship can see in the first paragraph.
Yes.
That is a learned counsel for Mr. B. Datto for the Union of India practically agreed. And in this judgment, Nakara has been considered. Nakara has been diluted in 1990. And Malat, in paragraph 7, Devakinandan has also been considered. But Devakinandan has been considered by the Supreme Court in paragraph 7. But when Devakinandan said that right to get pension is a fundamental right, but Article 31 and 19(1)(f) has been deleted from the Constitution in 1979. After that, can my land fund say that this is my fundamental right to get pension from the government? There is no pleading that there is no legislative competency. There is no ground that state government has no legislative competency to make the rules. Number one. Number two, there is no pleading that any other provisions of the Constitution has been violated by this rule. Number four, my land fund that other pensioners family are getting family pension. Why I not get? When a family pension, when a country do 101.
Yes.
Rule shall subject to the provisions of the apply in case of the death of a government servant while in service. Then who entered service on or after 1st April 1965. Who was in service before 1st April 1960 and has not opted for specific or to come under the scheme and rendered at least 3 years service. Not apply. The benefit shall also be admission in case of death after retirement. If the time of death the retired officer was in receipt of a compensation invalid requiring on superannuation pension or gratuity provided. On a pro rata pension has not been mentioned deliberately. Whatever may be the reason. Then once, if Rule 101, read 189 is read together, what is the harmonious construction to be there? If he was getting pensioned or they have accepted that family pension scheme under the disabled scheme, certainly my land fund. But that cannot be said that's violation of Article 21 or Article 40.
Yes.
But according to the judgment of Devakinandan, till 1979, right to pension was a
26/7/1979.
chapter close. Then legislative competence is there. There is no provisions or other provisions of the Constitution, and there is no violations of on Article 21. Everybody will say that no, I will get pension.
He is not on the legislative competence, and he is not on. He is alleging, or it is his case that since there can be no two class of pensioners, this classification is not based on an intelligible differential.
What is intelligible differential? If my advice stands like other private pensioners, that means either death or getting pension at the time of retirement. Pension does not include pro rata pension. Nowhere included defined in the rules. Pension include pro rata pension.
Pension does not. No, that is there. Pension only includes gratuity.
Pension includes gratuity. And he has not got the gratuity. Separate provisions have been made. That's why. When the legislature is making the legislation, because the rule 309 may be framed by the executive, but it has to be placed before the House. If House approved it, then it has to be notified by the with the concurrence of the Honorable Governor.
But this argument of yours that pension does not include pro rata pensioners, that appears to have been rejected by the tribunal in the earlier occasion, when it said that you have to be at par with, they have to be kept at par with the other pensioners.
Can you see the language used by the division bench? Page 62.
Page
62. Fifth line from bottom.
62.
62 of the supplementary.
Can you refer to the informal paper book?
Yes. Yes. 1 second. Yes.
Page 59.
Page 59.
59.
Paper book, paper book.
Sorry.
Page 59 of the paper.
Yes.
Page 59. It is page 59.
62 যেটা
59 was
59.
আরো পরে যাবে, আরো পরে
59 টা খুলো না আমি বলছি।
পরে যাবে। আরেকবার ব্যাস এইখানটা।
মানে page 59. 62. 59 of the paper.
Page 59 of the paper.
Page 59 of the paper book.
তাড়াতাড়ি। Argument.
Fifth line from bottom. The argument to the effect there is no obligation on the part of the state government to adopt all the rules applicable to the state government employees and self-government pensioners has been rightly discontinued by the learned tribunal on the basis of the direction of the Supreme Court in case of welfare association absorbed central government employees in public enterprises. In case of state of Bihar and others, as relied on the dismissal was the Pitman Committee ignored the terms or references contained in the resolution of the state government. And erroneously recommended the revised pay scale and the backdrop of the facts it was internally observed. The pay scale essentially depends upon the resources of the government, and that it is not always possible that the resources of the central government and the state government are the same or in that matter between the two states. In case of state of West Bengal Supra, the controversy involved concerned around the issue as to whether the senior deputy assistants in the public works road department are entitled to same pay scale at par with the research assistants, and to whether chief engineer of the directorate was competent to modify or amend the ROPA rules. In none of the said judgments leaves pending pertaining to pro rata pension and gratuity to government servants absorbed in public sector undertaking that was such judgments are issued. The total that what cannot be covered by a writ has to be an error of law, but must be such error of law can be regarded as one which is apparent on the face of the record. The learned tribunal, upon dealing with all the factual aspects, arrived at a specific finding on the consents of the judgments of the Supreme Court, and who do not find any error, least to say that the patent error of the judgment into that the model employer the government must conduct itself with a high probity and do not to ensure that employees do not succumb to the failure, particularly when the claim pertains to pension benefit. Scope of judicial is very narrow and limited. Some judicial should be exercised frankly, and when appropriate case where judicial concerns of the architect, the delinquent judgment does not from any substantial failure of justice or manifest warrant interest court.
Pension.
Yes.
Pension is regard to the pension,
Not family pension.
not family pension. There is no discussion about family pensions who was not in this.
Yes.
ব্যাপারটাই উঠিয়ে দেওয়া দরকার।
When if we say that pro rata what should be deleted, then what is the meaning of absorption in another undertaking?
They are getting the provident fund.
They are getting the provident from the Food Corporation of India. They are getting the gratuity from the Food Corporation of India. They are getting another gratuity act. Food Corporation India act. I hand over the Food Corporation of India Act 1964.
What is it?
Its date of effect and I'll make another copy and hand over. The official date is there, brother. This was 2010 and 12 November 2008. An agreement 26 November 1966.
So they were absorbed with effect from the date of agreement. With effect from or by the order of by the agreement itself.
Subject to correction.
But this date, how does it make a difference?
Language. 101.
Yes, 101 already.
Who entered service order after 1st April
85. That is CRB টা বল।
DCRB.
So they were not in service.
They are not in service.
101.
101. Enter into service. But they have entered into service prior to that.
So, my lord, the husband of the petitioner entered into service in 1966. And another entered into service in 1958. And
But
according to
agreement was
provisions.
26 November 1966.
So it is after this date. That date is not relevant. They were absorbed after coming into force.
But these data is relevant for admissibility of family pension.
But at that point of time,
Who entered service on or after 1st April 65? They are saying they were working since 66.
back to 1966. How they could be?
Huh?
If they were not, agreement was agreed on 26
No, no. What is the factual position? First clarify the factual position.
They were the entrance of the state government.
When?
65 up to 65.
Up to 65, yes.
They batch of batch petitioner. But ultimately agreement was executed by the government of India and government of Food Corporation of India 26 November 1960.
Yes, that date you have given us. Agreement is 28 November 66, not 26 November.
28th November. Order 28th November.
Oh, sorry.
So 28 November 66, they all became employees of the FC.
Food Corporation of India.
They are sent on deputation to work under Food Corporation of India in terms of that agreement, my lord.
Yeah, under the agreement.
Under the agreement.
And absorbed later.
Absorbed later in 1984, after rendering more than 18 to 20 years of service.
But we have got the all financial benefit from the date of the Food Corporation.
No, that is all right. We are just trying to understand whether this date has any relevance. Because the facts are such that they were not absorbed till much later. This date, whether it will have any relevance.
No,
With effect from
The issue remains whether they can, what you have raised, whether as a pro rata pensioner, they can claim parity with pensioner.
only that question.
And the effect of Rule 189, whether it operates in any way to be discriminatory. Because there is a specific provision saying that Rule 15 will not apply to such and such persons, and they are covered by that. This is your case. And regarding the other grounds are not available, which you have said that other grounds of legislative competence is not available. It is not a fundamental right. Those two issues does not arise. The issue whether there is parity or disparity, there is no issue according to you. Because they are pro rata pensioners, they cannot claim parity with pensioners. They have become employees of a different organization. They are getting all the benefits. The husband has accepted it with open eyes. This is your. So whether it is a valid classification or not,
Valid classification is not. Test of reasonableness.
neither of you have cited any judgment on this issue.
Reasonable classification, my lord.
Yes, that is the issue which you are arguing, both of you. But neither of you have cited any judgment on that issue.
But I can cite a judgment.
If you want.
Because my lord friend pressed upon judgment of 1971 Supreme Court.
No, that is, but the basic issue is whether the classification is sustainable, it is founded on an intelligible differentia or not. That is the only issue.
My lord, this judgment refers to all Manipur Pensioner Association appellant versus the state of Manipur and others. The
Like you, citation.
No, just cite some judgment. For the court's assistance, what is the latest judgment on this aspect? We'll just see that.
AIR 2019 SC 3338, 3338. And the relevant paragraph is para 8 at page 24.
Manipur.
Manipur. Even otherwise, on merits also, we are of the firm opinion that there is no valid justification.
Just give us a minute.
Right.
Right.
ডাউনলোড করেছি এখানে নেই কেউ বাড়িতে আছে মণিপুর থেকে আপনার কাছে
This is regarding fixing of a cutoff date.
Cutoff date, my lord.
Fixing of a cutoff date for the grant of revision.
My lord.
And therefore whether between pensioners
pension or not.
This is a difference.
So, my lord, there is a discussion on the reasonable classification.
Which paragraph?
Paragraph 8, my lord. Page 24. Even otherwise, on merits also, we are of the firm opinion that there is no valid justification to create two classes, viz. One who retired pre-1996 and another who retired post-1990.
Therefore, we said it is regarding fixing of a cutoff date.
My lord comes to all the pensioners form a one class who are entitled to pension as per the pension rules.
Correct.
Article 14 of the Constitution of India ensures to all equality before law and equal protection of law. At the juncture, it is also necessary to examine the concept of valid classification. A valid classification is truly a valid discrimination. It is true that Article 16 of the Constitution of India permits a valid classification. However, a very classification must be based on a just objective. The result to be achieved by the just objective presupposes that the choice of some for differential consideration of treatment over others. A classification to be valid must necessarily satisfy two tests. Firstly, the distinguishing rationale has to be based on a just objective And secondly, the choice of differentiating one set of persons from another must have a reasonable nexus to the objective sought to be achieved. The test for a valid classification may be summarized as a distinction based on a classification founded on an intelligible differentia. My lord, it has been categorically upheld by the court that there is no intelligible differentia between two group of pensioners.
See, therefore, wherever a cutoff date as in the present controversy is fixed.
My lord, I am dealing with the principles of the reasonable classification.
That principle applies in fixing cutoff date also.
Cutoff date also.
So this is an issue arising out of fixing of a cutoff date. This is not a issue arising out of two different sets of pensioners under two different circumstances. Here, both the pensioners are in the same state government service. They are drawing pension. They are admissible to pension at par. Whether revision can be distinguished or not, that is the issue.
My lord, my submission is then when it is held that there is no intelligible differential between two groups of pensioners.
When it is held, yes, then of course, then it has to be.
Then any discrimination, any unreasonable classification will offend the constitutional provision under Article 14. And my lord, so far the pro rata pensioner is concerned, my lord, may kindly for the moment come to page 21 of the paper book, where is the PPO of the husband of the petitioners has been annexed. There is no whisper about pro rata pensions. In fact, my lord, pro rata pension has been used to indicate that they are getting pensions on the basis of the service rendered by them, or the pro rata service rendered by them. They have not completed the 33 years service, which was the requirement for getting full pension at that point of time. They had rendered 18 years or 20 years of service, so they are getting the pro rata pensions.
Yes.
My lord, all these points were not taken up before the learned tribunal when they used their opposition. My lord, may kindly come to page 49.
Which point was not taken up?
49 opposition given by the state.
Which point was not taken up?
These pro rata pensions, etc. My lord, may kindly come to page 49. Subparagraph D. That assailing the judgment dated 21st June 2013, the state preferred 4 writ applications WPST 278 of 2014, State of West Bengal and others versus Ranjit Chandra, etc., my lord. After hearing the rival submissions of the respective parties, Honorable High Court Calcutta, in terms of judgment dated 1st August 2016, observed that we do not find any reason to interfere with the judgment impugned, and accordingly dismissed those 4 writ petitions. A copy of the judgment, sir. Then paragraph E, my lord. Then it can be deduced from the above facts that as the appeals of the state has been dismissed by the Honorable High Court, now the judgment dated 21st June 2013 will prevail with the solemn sanction of the Honorable High Court. that as the issue have already been decided now, there is no further scope to reopen the issue so far as the doctrine of res judicata is concerned. They have dealt with only on
Next paragraph, read the next paragraph.
That it is also to be enunciated that the husband of the petitioners are pro rata pensioners. Those deceased person enjoyed the benefit of pension meant for them during. But my lord, this
So this was raised by them. How you are saying this was not raised? This has been raised by them.
but they have not explained the nature of pro rata pension.
You said they have not. This is the issue raised by them.
Just on the generic name pro rata pensions.
This is their case. In fact, they have before the tribunal said that one, it cannot be reopened because this relief has been denied in the earlier way. That matter has been affirmed by the High Court, res judicata, and the other is what he is arguing today. That also there, both issues there.
And again, my lord, a clear reading of provisions of contained in 101 of the DCRB rules clearly manifests that any retired person who was in receipt of a pension, the widow of the deceased that pensioners will be entitled to have the pension.
Yes. That is all.
That's all.
The submissions. And this memorandum of 25 to 2009 has been given by you. In this case, no, it is. Are the parties. The judge. Give him the book. With
Grateful to you.